An application in connection with a second appeal. Extreme urgent not injunction application.
Yes,
Not
yes.
suit is for not any day. Lordship
Yes,
kindly
yes, yes, it
fixes
will
the
appear.
matter a particular day.
Let it appear, okay.
Not for any particular day. Not
No,
possible.
no, let the matter appear, definitely I shall consider.
Not second appeal, not hearing.
Hearing next week.
Next week, yes, not let it.
Next week I shall take up hearing matters, okay. Just wait for this week. Yes.
The two applications for inclusion.
Is it a hearing matter?
Applications and also one application for fixing the matter, the month of March.
No, application for what?
Application for experience hearing because
So you please wait.
2014.
Whatever it is next week.
1 month ago, file has
Very well. I shall take next hearing matters next week. I'll take hearing matters next week.
I'm making
No, I am not taking any hearing matter this week.
not hearing matter.
Application for expeditious hearing means ultimately the matter has to be heard out. Okay.
Other your lordship may fix the matter in the month of March, April, any day at 10:30.
So why? What is the necessity?
I requested Mother your
Okay. Next week it will appear as either to be mentioned or it will be listed for hearing. You see, I am not taking any hearing matter this week. Next week definitely either to be mentioned.
So that Mother
All sleeps will be taken up.
only Mother I am giving the list of the cases.
List of the
List of the cases, Mother, which Mother file has been list to your lordship court. Mother, 1 month ago.
No. Whatever it is, you see, whatever it is, again you okay, give the slip. It will be verified.
My lord, for upgradation, item number 186.
Please. Next week. I've given indication. Any upgradation next week, Monday.
Fixed on 17 November, it has not come, your lordship.
17th November. Which matter?
Lordship, miscellaneous appeal, your lordship, claim case.
Claim case hearing.
Lordship, yeah.
Try on Monday. Okay.
Sir, may I permitted for mentioning for inclusion the list, my lord. Hearing, my lord, previous 2 occasions I was mentioned, my lord. My matter was allowed, my lord.
Okay. I shall take it up next week. Monday I shall take it up. Hearing matters.
Lordship, may I be permitted to mention one application for condolation?
Yes.
This matter, this matter has been settled. Lordship, kindly send this matter for cash withdrawal, Lordship.
Okay. To be mentioned.
Nothing.
Application 42.
Item 51.
42.
Yes, item 42. Yes, what application needs to be taken up?
I think there is a disposed of
Let me see.
recording major can two of
दिन कैंटूटा देखिए Jan 2 of 2025. This is for recording majority.
And another
majority of claimant petitioner number 5.
Yes.
Husband of and father of petitioner number as
there is the correction of name.
Okay, so far the majority of petitioner number 5 is to be considered. Okay, Intazul Sek.
Yes.
And father of petitioner number 2 to 5. That is the prayer made in 211 also. FMA 211.
Can you make it notice? Let Mr. Rahman come. Yeah.
Okay, not today. Oh, not this week.
This is insurance appeal. This has come up against an award passed by the Employees Compensation Court. Today, I was only praying, your lordship will kindly condone the delay. And then, your lordship, as far as the admission of hearing of appeal is concerned,
43 টা ডেকে দিন তাহলে।
আমার 44.
Yes, call 43. No, 43 কি not this week? 42 টা তো not this week হয়েছে। 43 টা ডাকুন। Yes, 43. Okay, not this week. Yes,
I've
44.
served, your lordship will only condone the delay, and then your lordship, pass a direction, let the matter be taken up by the bench having the determination with regard to the admission of appeal. The Honorable Division Bench will admit the appeal, and then again, after admission, on the point of substantial question of law, it will come back to your lordship.
Admits well and good, otherwise it goes.
Yes, if they admit, then matter will again come back to your lordship for hearing.
Single bench.
Before single bench. I'm grateful to your lordship.
Yes.
Your lordship today will only condone the delay, and then your lordship will kindly direct the matter to go before the appropriate bench for admission.
This is complete.
Service, I've done. Awarded sum is deposited before the concerned employees compensation.
That has to be considered by the division bench.
Your lordship will record the awarded sum is deposited before the employees compensation court.
Awarded sum.
Lordship.
Yes, record an order. Learned advocate for the appellant is present. None appears for the respondents in spite of service of notice. Let the affidavit of service filed be kept with the record. The application for condonation of delay being Can 1 of 2025 is taken up for consideration. Our learned advocate for the appellant peruse the petition filed. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that sufficient ground is shown for condonation of delay. Thus, delay in preferring this appeal is condoned.
Grateful to you.
The receipt showing the deposit of entire awarded sum filed by the learned advocate for the appellant be kept with the record. Let this matter be placed before the Honorable Division Bench, having determination for further consideration and admission.
Extremely grateful to your lordship. I'm obliged, madam.
Hmm. 45. Okay, not today, not this week.
46.
My lord, praying for not this week, my lord.
Not this week.
47.
My lord, 47, I am appealing for the respondent claimant, my lord. The matter is, my lord,
What is this application for? Can 1?
Can 1.
47, you are appealing for the respondent. What is this application? Let me see.
My lord, for disposing of the ST application.
Let me see. Can 1. Okay, this is an application for stay. Anyway, not this week.
What
Yes.
is, my lord? I am.
You are for the appellant.
My lord,
Yes.
this is the affidavit of service, my lord. There is one, can 2.
Yes, service is complete.
My lord,
Yes, record an order. Learned advocate for the appellant is present. Hard learned none appears for the respondents in spite of service. Stop. Let the affidavit of service file be kept with the record. The application for condonation of delay being CAN 1 of 2025 is taken up for consideration. Hard learned advocate for the appellant peruse the petition filed. Stop. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that sufficient ground is shown for condoning the delay. Thus, delay in preferring this appeal is condoned. CAN 1 of 2025 stands disposed and the appeal is admitted. Stop. The application for stay being CAN 2 of 2025 is taken up for consideration as the appellant insurance company. You have deposited this. Appellant insurance company has deposited the statutory amount.
No. I will deposit after the order, my lord. After the order of stay, I will deposit the entire awarded amount within 4 weeks.
Okay. The application for stay being CAN 2 of 2025 is taken up for consideration. Learned advocate for the appellant insurance company prays for time to deposit the statutory amount. Stop. Thus, time to deposit the statutory amount is granted.
My lord, no. I have deposited the statutory amount and the balance awarded amount I will.
So, where is that document? You have not filed. Is there any order recording that you have deposited?
My lord, I have the challan, my lord.
Okay, then file that. So that is what I am recording. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated
দিয়ে দিন ওনাকে।
dated 25th day of April 2025, passed by learned additional district judge, first track third court, Barhampur, Murshidabad, for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. Within five weeks. In the event the awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Registrar General High Court Calcutta is requested to invest the sum deposited in a fixed deposit of a nationalized bank and renew the same from time to time. Liberty to mention.
I am grateful, my lord.
There is only one application for stay, and this appearing for the first time. I have deposited the statutory amount of rupees 25,000.
Yes. Learned advocates for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 26th June 2025, passed by learned additional district judge, first track second court, Barhampur, Murshidabad, in MSCC case number 155 of 2018 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop.
Less statutory.
Along with the interest as directed by the learned trial court, excluding the statutory amount within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Stop. The Registrar General High Court Calcutta is requested to invest the sum deposited in a fixed deposit of a nationalized bank and renew the same from time to time. Liberty to mention.
Grateful to Lordship. My lord, the next is also same, my lord. Only one application for stay. Is the statutory amount. My lord, here, my lord, only one, my lord.
Yes, record an order.
My lord, only one thing, my lord.
Yes.
Yeah, my lord, kindly come to my lord, page 12 of the award.
Page?
Page 12. In our page 12 of the award, my lord, in the memo of appeal, my lord.
Operative portion.
Operative portion, order in portion, my lord, my lord, last but third paragraph, my lord, the claimants will be at liberty, my lord. My lord, default interest was granted, my lord, kindly direct the insurance company to pay the interest, 6% interest. From
Whatever is the direction of the trial court, that I am passing. Okay, whatever is the direction. After at the time of hearing of the appeal, all this will be considered. Learned advocates for the appellant insurance company is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 17/9/2025, passed by learned additional district judge, first track 5th court, Barashat, district North 24 Parganas, for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court, excluding the statutory amount, within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Stop. The Registrar General High Court Calcutta is requested to invest the sum deposited in a fixed deposit of a nationalized bank and renew the same from time to time. Liberty to mention.
Grateful to Lordship.
My lord, for the appellant, my lord, the CAN application is one application under section 5, my lord. The delay is of 167.
Service is complete. Service upon the
My
respondent.
lord, upon 2 respondents is complete, my lord.
Okay, let me see.
My lord, yet it has not been affirmed, my lord, but old CAN of 2027, my lord. 2017. The order was passed
Oh, question is,
to service.
how long is the delay?
167 days, my lord.
So how many? So service is complete upon 2 and 3.
Service is complete upon, my lord. Konika Mondol. Check karo Konika Mondol.
No, how many? Who are you are the plaintiff before the trial court?
No, I was the defendant, my lord. They were the plaintiff. Opposite parties were plaintiff.
So service is complete only upon 2 and 3.
Konika Mondol, দেখো Konika Mondol কত? আগের পেজে.
So state of West Bengal should also be served.
Yes, my lord. My lord, should I serve again, my lord, as this was served?
So let the service be complete.
My lord.
Yes, record an order. Learned advocate for the appellant is present. As the service upon the respondents is not complete, the hearing of this application under section 5 of the Limitation Act stands adjourned till 26/2/2026.
Well,
Let this matter appear on 26/2/2026 under the heading application.
much obliged, my lord. of these two. Yeah. Your Lordship, I'm not the respondent in this matter, Your Lordship. I'm led by Mr. Chan Gupta, sir, in this matter, Your Lordship. He's running.
So what application is to be taken up?
My lord, there are two applications, my lord.
Yes.
One is an application, both are my applications. I am the
Yes.
appellant. One is my application for extension of the interim order. And the other, my lord, is an application, my lord, for stay, where limited stay was granted, but then it was held by the learned division bench at the time of granting of stay that the issue of occupation charges will have to be decided at the time of
Let
hearing.
it be not this week, come on Monday. Because
Very well.
any execution case is pending.
Execution case is
When is
pending.
the next date fixed?
21st February, my lord.
Okay. So
My lord, Monday.
Let it be not this week. So come ready on Monday.
My lord, as long as it retains its position, my lord, I have no
Yes,
difficulty.
yes. It will retain its position, not this week only.
I'm grateful.
My lord, learned advocate for on behalf of the appellant, Mr. Uttio Rai, due to his unavoidable circumstances, is not
Okay, not this week.
not this week. Much of this, my lord.
Yes, not this week. Same.
57, I am for the petitioner, Mr.
Yes.
Mr. Cormac is also leading.
56.
I'm for the respondent number 1, my lord.
Okay, appellant is not there. I made it not.
Yes, yes. Yes, sir.
56. Not this week.
57. Oh, 57.
Yes.
Fine. No, no. 57. Yes.
Lord, I beg to appear for the appellant in this matter. Lord,
And one is for?
Lord, can one is for injunction. Now, Lord, appeal was admitted. Your Lordship would kindly see, Lord, the admission order, paragraph number 7 and 8. Two sorts of injunction we had prayed for. One kind, Lord, we were granted by the Honorable Division Bench. The other part was, Lord, left, Lord, for your Lordship to adjudicate. Yes. It was yourself ke last order.
Admission order.
Order dated, Lord, 1st of December. Kindly, Lord, comes to paragraph number 6. That's the injunction granted.
Anyway, your eviction suit was dismissed by both the courts.
Yes.
Now, what is the interim order?
Kindly see paragraph number 6. We were granted that order.
Yes.
Then, Lord, kindly comes to paragraph number 7.
Yes.
This is exactly, Lord, what I will be pressing for before your Lordship today.
Prayers regarding direction to allow the meter readers to take meter readings since.
Lord, the meter room of the entire building is situated within the suit premises. And Lord, because they are in possession, they are not allowing us to, Lord, take the meter reading. Only, Lord, to that extent that.
So earlier, how is to take the meter reading during pendency of the suit?
Yes. Access was there. Till that time, access was there. Now, Lord, after the suit was dismissed, they have completely stopped.
No, meter reading means whose meter is that?
Our all entire building's meter is there.
Entire building meter.
Entire building's meter is there.
No, meter reading is taken by the CSC authorities.
Yes, that access is prohibited.
WBACP.
WBACDCL, not CSC.
WBACDCL.
Only to that extent. That as and when Lord required, they will give us access.
So earlier it was given.
Earlier it was given. No difficulty.
So is
and
there?
They are bound to give also.
No, is there any bill that they did not? They did not give you access to the meter reading for which
Lord,
this reminder bill is given.
Same thing is happening. Lord, what happens is these days, Lord, they generate a standard average meter bill. So, Lord, I have to
when meter reading is not taken.
Yes, that's exactly what is happening. So, Lord, there is no harm. I'm not asking for delivery of possession. What I'm asking is this injunction I'm having at paragraph number 6. In addition to that, Lord, what I'm praying before your Lordship is that an access to the meter will be granted as.
So, did you file any affidavit to this application?
Affidavit services are filed.
No, they have filed any affidavit in opposition.
They are with me. Respondent blood is not appeared.
Oh, I thought
We have served. Pursuant to the admission order, we have served. Received? Not naturally. They will
respondent
not.
has not entered appearance.
They will not.
One Mr. Zakir,
Ache?
Zakir Hossain has filed wakalatnama.
Oh, Wakalatnama has been filed.
So
my lord,
better serve him.
Zakir Hossain. Notice was served upon him. Prior to
No, I'm fixing the. I'm fixing.
was prayer and kindly fixes the. I mean, any day, my lord, we'll prepare the paper books and come back to your lordship.
No, I just give him one more chance. Okay, on that day I shall pass necessary orders. Or I'm keeping it on Monday. I'm keeping it on Monday or Tuesday.
We shall put him on notice again.
Yes. I'm fixing it on Monday. Or
Kindly makes it peremptory. In that case, in their absence, it will be heard. Kindly makes that order. Else, my lord, again the same thing will happen.
Yes, record an order. Learned advocate for the appellant is present. The application CAN 1 of 2025 is taken up for consideration. Hard learned advocates peruse the petition filed. As the learned as none appears for the respondent today, in the interest of justice, matter stands adjourned till (17) to 2026. Stop. It is hereby made clear if none appears on the said date on behalf of the respondent.
Lordship's pleasure to take it up Monday, my lord, 16th.
Okay, you have difficulty 17 and 18.
Lord, very Monday not possible.
Monday I cannot assure you anyway. Just I'm keeping it a Monday. Acha, Sombare it will remain in the list. Okay, 16 to 2026. It is hereby made clear that if none appears for the respondent on the said day, the matter will be taken up in his absence.
Read. In notice.
Yes, not this week.
To my lord, I am appearing on behalf of the appellant. Claimants of the appellant before your lordship. I have come before your lordship only twofold ground for enhancement. One is my lord income, another is my lord deduction. This is a case death of a 74 years businessman. Business was my lord. He was a dealer of the kerosene oil. My lord, kindly see page 1 at first. My lord, wife, sons and daughters are the claimants.
Yes.
And my lord, your lordship kindly see serial number item 3, serial number 3, age of the person 74 years at the time of death. My lord, thereafter, my lord, your lordship will find my lord, occupation of the person dead, business, kerosene oil dealer. My lord, inspector under inspector food supplier.
Okay, he was inspector.
No, he was not. He was dealer.
Dealer, right.
Yes, under inspector food and supply. And due to my lord, here one question is there, my lord. Monthly income has been written in the claim application 6,000 average. But the document which has been exhibited from the my lord food and supply inspector, my lord, I am coming here. Your lordship kindly see my lord PW2 at first. PW2, my lord, page 13. For the this is my submission is regarding my lord.
Page 13.
13. This is for my lord. First question, first points, my lord, regarding assessment of monthly income. I am presently posted as Inspector Food and Supply, Mohisadal Block. I am summoned witness as per the direction in the said summon issued by this court. I have today produced certified true copies of letter dated such and such issued by district collector regarding fixation of division price of SK oil along with enclosure comprising 3 separate sheets. This is the said document. It has been certified by myself, mark 15, exhibit 15. I have also submitted the copy of the letter dated such and such in respect of tagging the deceased victim Susanto Bhuia's dealership with that of Nandalal Pradhan, along with the copy of the approvals dated such and such. The letter has been marked Matter Exhibit 16. I have also furnished the certified true copies of the statement of allotment of SK oil in the first and second phase of the month of December 2017. My lord, accident took place in the month of January 2018. My lord, before that, my lord, that document has been submitted and that has been marked as Exhibit 17. And thereafter, my lord, kindly see the deceased victim being authorized kerosene dealer used to receive the SK oil from government at rupees 28.94 per liter, and he was permitted the same at rupees 31.39 per liter. In the month of December 2017, Susanto Bhuia was allotted 3448 liters of SK oil for sale. Presently, the commission given to the authorized SK dealers rupees 3.36 per liter. My lord, kindly mark it. Kindly mark it. Regarding assessment of income, my lord, here, my lord, kindly see the impugned judgment.
So question is,
What
on the sale of liter,
my lord, 3 point, my lord, that is the
of the
profit.
sale of liter,
Yes.
3.36 was the commission.
Yes.
So allotment was 3,448.
440 into, my lord, 3.36, it will come, my lord, 11,000 odd.
Yes.
11,000 odd per month income. Here, my lord, kindly see page 25, my lord. Page 25, my lord, the regarding, my lord, assessment of income, my lord, paragraph 19.
Yes.
Based on this claim application, I have perused the documents marked as exhibit. In this case, it was alleged that the claimant, that the victim used to earn rupees 6,000 per month from his business as a kerosene oil dealer, and that income was his monthly average income. In support of the said claim, PW2 was summoned, and he has adduced his evidence and proved certain documents which were marked as exhibit 15 to 80. In this regard, the tribunal have perused all these documents, and it is found that the victim was a kerosene oil dealer and he used to earn a margin money per liter of kerosene sold from his outlet. He used to be allotted kerosene oil from time to time, but it is without doubt that different quantities of kerosene oil used to be allotted to the victim in different months. Thus, his income was variable and cannot be quantified with certainty. But it is seen that as per the allotment of kerosene oil and given amount margin money used to earn of the claim of having average monthly income to the tune of rupees 6,000 is not implicated at all and can be accepted without further scrutiny. My lord, here, since the nature of thereafter, my lord, 6,000 has been allotted. But the fact is that when the margin money is 3.36 and, my lord, the liter per liter has been allotted according to, my lord, the inspector, that is, my lord, 3448, it will come, my lord, over, my lord, 10,000. Yes.
11,000.
11,000, yes. এটা দিয়ে দাও দা। আচ্ছা, just check করো, একটা স্যারকে দাও।
No, is it they are in the record? Have you exhibited?
Yes, that has been exhibited. 15 to 18. My lord, kindly, this is my submission. My lord, I am coming one after another. Yeah, here one question may raise that since, my lord, in the claim application, 6,000 has been paid, whether the court can go beyond that claim. My answer is, my lord, yes, that can be done. The Honorable Apex Court has said so in several decisions. My lord, I am coming. I shall place before your lordship. In Sanjay Verma, it has been stated that can be done. If document is there, then my lord, document has to be taken into consideration in calculating the compensation amount. My lord, this is the first point. Another point is, my lord, regarding deduction. Here your lordships will find in the same judgment, my lord, paragraph 20 bottom portion. My lord, same page 25, page 25.
Yes. Here
Now-
you see, considering the age, no question of future prospect.
No question of future prospect.
Multiplier is also correct.
Same, multiplier is also correct. My point is, my lord,
Monthly income.
monthly income and deduction. Because of the fact, my lord, number of claimants are 6. Wife, sons and daughters. Here, my lord, 1/3 has been deducted. Considering that there are married daughters, whether married daughters is to be taken into consideration in calculating the compensation amount or not. My lord, honorable appeals court has dealt with. In the case, I am placing one after another. In the case of your lordships, will find that regarding deduction, Simarani's case, my lord, under BC, here it has been held, and our High Court also held in Josna Bera's case. My lord, I am placing one after another, my lord. তার প্রথমে দিতে হবে regarding income. Sanjay Verma, yes. At first, my lord, I am placing regarding income. My lord, here, my lord, kindly see Sanjay Verma.
Total sum awarded, how much compensation?
Compensation are 2,40,000. 2,64,000.
Now let us see. Now the question is, this is with regard to Sanjay Verma. This is not a death case.
Death case, no, injury case. My lord, but the question, if I claim 15,000,
let us,
kindly see.
No, as per Sarola Verma, how much it comes? So far the dependents are concerned.
My lord, it will 1/4. It will be 1/4.
Okay, and Pranay Shetty?
1/4. Because of the fact, Pranay Shetty, my lord, affirmation, Sarola Verma, and as well as Rajesh Vyas's judgment. I also, my lord, place Pranay Shetty. Regarding income, my lord, I am placing, my lord, kindly see, my lord, Sanjay Verma's case.
Here you see.
Paragraph, yes.
Now the question is, the learned judge also awarded 2,64,000 for
Yes.
consortium.
Yes.
So you cannot get more than 40,000.
Consortium for 3 persons.
So
6% ধরা হয়
6%. Yes, my
all
lord.
persons, you know, no.
My lord, here also, my lord, Satinder Kaur's case, your lordship knows that. And
See,
after considering,
now the question is Pranay Shetty. Pranay Shetty is to be followed only 40,000. No, have you challenged that issue?
No.
Regarding grant of consortium?
No. That has not been no cross objection, nothing.
You have not filed any cross objection anyway.
And my lord, kindly see, my lord, Sanjay Verma, paragraph 11. Kindly see for a moment. The appellant was a self-employed person. Though he had claimed a monthly income 5,000, the income tax return filed by him demonstrate that he had paid income tax on annual income such and such. No fault, therefore, can be found in the order of Honorable High Court, which proceed on the basis of the annual income of the claimant at the time of accident was rupees 41,300. In the claim application, in the instant case, my lord, Sanjay Verma, in the claim application, it was mentioned claim, my lord, income 5,000, but document has to be taken into consideration. And another, your lordships will find, my lord, the Rajesh versus Rajveer. My lord, kindly see. এটা দিয়ে দিন জজ সাহেবকে। My lord, Rajesh versus Rajveer. My lord, paragraph. দাঁড়ান দেখি একটু দেখাতে হবে।
Yes.
Paragraph 10, page 30, Rajesh versus Rajveer. Whether the tribunal is competent to award compensation in excess. Paragraph 10, page 30.
Page 30.
Yes.
Yes.
My lord, whether the tribunal is competent to award compensation in excess of what is claimed in the application under section 166 Motor Vehicles Act such as this is another issue arising for consideration in this case. My lord, thereafter, my lord, section 168 has been coded, and thereafter, my lord, kindly see paragraph 11, underlying principle discussed in the above decisions is with regard to the duty of the court to fix a just compensation, and it has now become settled law that the court should not succumb to necessities or technicalities in such matters. Attempt of court should be to equate as far as possible the misery on account of the accident with the compensation, so that the injured oblique dependent should not face the vagaries of life on account of the discontinuance of this income earned by victim. This is another, my lord, here your lordship will find, my lord, the just compensation has to be assessed. Whatever be the claim, thereafter your lordship will find the FIR can be treated as claim petition. Thereafter has been written. Section 158 has been coded. Paragraph 14. Next page.
Yes.
Section 158 subsection 6, the FIR and the report of the police can be treated as claim petition. হ্যাঁ সব দেবো, ওগুলো লাগবে, সবগুলো দিতে হবে। Then my lord, I am placing another decision, my lord, Kirti. এটা একটু দিয়ে দিন। My lord, kindly see page 150, my lord, of Kirti, paragraph 10 and 11. My lord, same proposition of law has been, my lord, dealt with. My lord, kindly see page 150, analysis, my lord, deduction for personal expenses. We have thoughtfully considered the rival submission. It cannot be disputed that at the time of death, there in fact were 4 dependents of the deceased and not 3. The subsequent death of the deceased dependent mother ought not to be a reason for reduction of motor accident compensation. Claim and legal liabilities crystallize at the time of the accident itself, my lord, and changes post thereto ought not to ordinarily affect pending proceedings, just like how appellant claimants cannot rely upon subsequent increase in minimum wages. The respondent insurer too cannot seek benefit of the subsequent death of the dependent during pendency of the legal proceedings. Similarly, any concessions in law made in this regard by either counsel would not bind the parties, as it is legally settled that advocates cannot throw away legal rights or enter into arrangements contrary to law. Thereafter, my lord, 11, paragraph 10 and 11.
Yes.
My lord, the document which is there, that has to be taken into consideration. and document has been submitted by the food inspector. He himself come and deposed that the margin money is, my lord, 3.36. So, my lord, the income has to be, my lord, more than 10,000, not 6,000. Then, my lord, thereafter, my lord, kindly see regarding deduction what Punaysetti says.
Yes, which paragraph you have stated that 1/4 issue, that 1/4 deduction?
Deduction, my lord, regarding that is, my lord, that is, my lord, my lord. I have stated, my lord, page 31. For that the learned judge, while passing the impugned judgment and order, has not calculated the amount of compensation as per law.
No, which page 31?
31. Page 31,
Of
7.
Page of which
Of the
judgment?
paper book, paper book.
Okay.
Paper book. Of the paper book, I have stated, my lord, impugned judgment has not calculated the amount as per law. My lord, whether it will be 1/3 or 1/4, that is the question of law. I have stated my lord, the claimants are 6. That has been stated. Whether it will be 1/4 or 1/3, that is, my lord, question of law. Regarding, my lord, 1/4, my lord, I am coming. My lord, I am my submission regarding Punaysetti. Punaysetti, my lord, kindly see. Punaysetti টা দিলাম দিয়েছি তো, my lord, kindly see Punaysetti. জজ সাহেবকে হ্যাঁ ওই তো ওইটাই, মানে Punaysetti, my lord, page 689 judgment. Punaysetti judgment 689.
Yes.
Paragraph 39.
Yes.
That has, my lord, Sarla Verma, Resma Kumari has been dealt with. Here you lordships will find, my lord, though in some cases the deduction to be made towards personal and living expenses in calculated on the basis of units indicated in Tilakchand, the general practice is to apply standard deduction. Having considered several subsequent decisions of this court, we are of the view that where the deceased was married, the deduction towards personal living expenses of the deceased should be 1/3, where the number of dependents family members is 2 to 3, 1/4, and my lord, 2 to 3, and 1/4, where the members of the dependent family are 4 to 6. Here, my lord, number of family members and also the claimants are 6.
No minor. How many minors are there?
No minor. 6, my lord, there is no minor. There is no minor. Here, the learned tribunal below considered that since there are দাঁড়াও আস্তে আস্তে, since there are, my lord, দাও এটা সীমাটা আর একটা কোথায় গেল, এই যে এখানে আছে, ঠিক আছে. Since there are married daughters, that for that reason, my lord, 1/3 has been deducted. My lord, in 2025, your lordships will find, my lord, married daughters should not be discarded.
Yes. Which paragraph?
Paragraph, my lord. Paragraph 9 and 10. এটা হচ্ছে সীমা, এই যে 2020 সীমা রানী. My lord, paragraph 10, it has been stated, there is no reasons to exclude a married daughter from compensation. Paragraph 10, last portion. After considering Virender, And in a similar situation, after considering the judgment of the Honorable Appeals Court Birendar and also the Simarani, our High Court also held that, my lord, this is unreported. Paragraph 7. And actually 1/4 has been deducted. এটা তো দিলাম আপনাকে একটা কপি। এটা এটা নন্না বন্দ্যোপাধ্যায় স্যার। Paragraph 7. And ultimately 1/4 has been deducted. In this case also married.
Para 7.
Paragraph 7. The composite regarding the aforesaid decisions adduced right a legal representative to claim compensation
Just a minute.
in the death of the victim that has been stated.
No, para 7, that is para 6 is here, page
Yes,
3.
para 6. My lord, that para 6 is also there.
Yes, para 6 is page 3.
Page 3, yes.
Para
The observation of the Honorable Supreme Court, National Insurance Company, Birendar and Simarani. These two decisions has been, my lord, considered. একটাকে বিপাশাটা দাও। না দিইনি। হুম। Actually, my lord, under 166, the word, my lord, legal representative has been inserted. But once,
No,
no,
you see-
164.
see, right to apply is one thing, okay, as legal representative.
Yes, yes.
The other is with regard to that deduction. Okay, that is another.
In the evidence, it has been stated, my lord. All are dependent. There is no, my lord, contrary evidence. There is no contrary evidence. My lord, page 10. Page 10 of paper book.
Yes.
Page 10 of paper book, my lord. My lord, entire evidence has to be taken into consideration. Paragraph 4. That my husband was aged about 74 years, having sound health and good physique. At the time of accident, my husband was a kerosene oil dealer. By his profession, he used to earn rupees 6,000 per month from his business. My husband was the only one breadwinner of our family. We who not left behind cash, bank balance, and property. Without me, my married daughter, sons, and married daughters, we claimants dependent of our living upon my husband when he was alive. Now we have no source of any income to maintain ourselves. This statement is there.
Yes.
And another, my lord, decision কোথায় গেল ওটা দাও? Another, my lord, Bipasa Rai, our High Court also held that, my lord, regarding legal representative. My lord, same thing, my lord. Birendar Munford brothers has been considered. Paragraph 9. Paragraph 9, my lord, that has been clarified. This is our High Court decision. In the instant case before your lordship's hand, my lord, the food inspector has come and proved the commission, and liter of kerosene has been, my lord, rightly has been, my lord, produced before the claims tribunal, but the claims
No,
tribunal,
here, how many wife and how many sons and daughters?
my lord, total 6.
So how many sons out of 6?
3.
All are major sons.
Also, all major, all major,
All major.
all major, all major.
Page 25 of the last paragraph.
Yes. Yes. Page 25 last paragraph, and thereafter, my lord, page 26 first. Page 25 last paragraph. Up to 3 claimants, my lord, 1/3. Beyond 3, 1/4. This is my submission before your lordship, my lord. On this ground, my lord, the appeal should be allowed and amount of compensation should be enhanced.
Regarding 2021, which paragraph you have relied upon?
Regarding 2021, 21. Kirti 10 and 10 to 12. My lord, in my submission, my lord, this sheet, my lord, paragraph has been mentioned. In Kirti, my lord, minimum wages has been taken into consideration, irrespective of the fact. And regarding interest,
Yes, page 32 you are relying.
regarding, my lord, interest, my lord, lastly,
No, regarding the statement of PW, dependency.
dependency. 25.
Page 11.
Page 11. Page 11 is the, my lord, cross-examination. Page 11. That is the exhibited document.
Yes, what you say?
Here question is income and dependent. Regarding income, there are
Yes.
stated that as per the document
Yes.
produced by the witness number 2. Witness number 2, my lord, on December 2017,
Yes.
Sushanta Bhuya was allotted 3,448 liters of kerosene. And this is 1 month. My lord, your lordship, see the page 81. page 81 of the paper book. Yes. Sushant Bhuya, item number 15. Sushant Bhuya, the victim, allotted 4th December 1724 of liter of kerosene. Then my next page, item number 15, Sushant Bhuya
1724. Yes.
on
1724.
21st December 1724. Then I will come to page 84.
Yes.
Here, my lord, October 15, November 15, December 15, January 16, January, February, March, April, May, June, July, August, September.
Up
My
to
lord,
16.
Yes.
16, yes.
Up to 16.
My lord, your lordship, see allotment. Total allotments.
Yes. That is October 15.
3825.
October 3825.
November 15, 4087.
Yes.
4360.
Yes.
Thereafter, 3812. All, my lord, beyond, my lord, 34 such and such. 3448. All beyond 3448.
Therefore, learned tribunal assessed income on the basis of average income of 6,000 per month as per claim petition.
No, if this is accepted, for example, that 3448 or 3450.
Yes.
And 3.36, very well. 3450. Let us take 3. How much it comes?
3. It will come, my lord. এটা করো। আমার এটা কোথায় গেল? মোবাইলটা দিলাম। দেখো, করো। 3 into 3400.
3450 into 3.
3450. দাঁড়া। into 3 করো ওটা। এটা কত? আমার এটা লেখা আছে তো।
More than 9,000, 10,000.
হ্যাঁ, more than 10,000. That was my submission. 3 into 3448. করো। 3448. 448. More than 10,000. More than 10,000, my lord.
That means out of allotment, if we consider partly is sold.
Yes.
Yes.
He was big dealer. That has been stated by the inspector also.
Okay, this is with regard to the income. Yes.
Income. Secondly, my lord, deduction, my lord, it is admitted fact that 3 daughters were married, and they were residing in their husband's house. Therefore, as per Supreme Court decision, your lordship.
Yes.
The decision of Supreme Court is against my submission. But my lord, here, the consortium, but your lordship, income, my lord, they claimed.
Oh, you have not filed any cross
My lord,
objection.
my lord,
I
your
could have
lordship-
considered
Your
that.
lordship, see, your lordship, they claimed compensation in their claim petition, 6,000. In their evidence, 6,000. And learned tribunal considered 6,000. But if your lordship enhance the award on the basis of 168 of the Motor Vehicles Act, then your lordship also has a right to modify the consortium portion without any cross objection as a just compensation.
Yes, what was the multiplier applied?
5.
5.
5.
Yes,
Five.
that is correct. I have challenged my lord only twofold ground. One is my lord income, another is my lord deduction.
So total compensation awarded how much is?
My lord 5
2,64,000.
Yes,
2,64,000.
No.
2 lakh?
No.
Just see.
No. 5,37,000.
5,37,000.
Yes.
5,39,000 naki.
37,000 এই যে টোটাল
Uh-huh.
এই যে এখানে
Yes, my lord, 5,37,000.
page 26 my lord, page 26 of the paper book.
5,37,000.
Yes, my lord.
Yes, ma'am. Your lordship, come to page 26 of the paper book.
হ্যাঁ ওখানে দেখে নিয়েছেন।
Yes.
My lord, calculation. My lord, item number 7, consortium for 3 persons, 2,64,000. My lord, it was wrong, man. It was 6 persons.
6 persons means that is
That is married daughter.
2,40,000.
No, 2,40,000 award.
No. Suppose 40,000 multiplied by 6.
Yes,
So 2,40,000 maximum. it will go.
2,40,000. Thereafter, loss of estate 16,500, funeral expenses 16,500, and consortium 2,64,000. Total 5,37,000.
consortium for 3 persons.
এটা লেখা আছে 3 পার্সেন্ট দিয়েছে তো 6 জনের জন্য তুমি দেখো না এই সব 3% কত হয়
মানে that amount has been paid by the insurance company. That amount has been paid by the insurance
Okay, from
company.
72,000, you see,
Yes.
1/3 was deducted.
Yes.
That means
And- Yes.
24,000 was deducted.
Yes, ma'am.
So that came to 48,000.
Yes.
48,000, you see, the multiplier
5.
48,000.
Yes.
Multiplier was applied.
5. And this my lord amount has been paid by the insurance company. My lord, insurance company cannot raise any question after that. This is also settled. Your lordship knows that.
তুমি আরো বেশি নেবে আমি বলবো না,
তুমি তো জানো
তুমি বেশি নেবে আমি বলবো না।
তোমার তো হলো ওই ঘরে, তোমার ওই ঘরে হয়েছে, আমি দেখিয়ে দেবো। তুমি আছো আমি দেখিয়ে দেবো। হ্যাঁ, না তুমি নিজে জানো 2014 সালে তোমার সাথে হলো আশিকের মামলা, আশিকের সাথে তোমার মামলাটা হলো না?
So 2,40,000 was decided.
Yes.
Yes, ma'am.
আমার কাছে নোটিশ আছে ওটা 2014 সালে। ওটা তো সুপ্রিম কোর্ট থেকে দেখে করলো তো, 2014 সালে সুপ্রিম কোর্টে দেয়া আছে।
You see, consortium for 3 persons is, even if it is 6 persons also, how much it will come?
6%, 2,64,000.
10% will be added, my lord.
Okay, okay, 6%.
After adding 10%. But 3%, 1,32,000. Wife, one daughter and one son.
No.
Only wife, 44,000.
Yes, record an order. Learned advocates for the parties are present, heard learned advocates. The appellant before this court were the claimants in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated yes 31st day of August 2022, passed by learned additional district judge, first track first court, Tomluk district, Purbo Mednipur. Stop. In MSC case number 235 of 2018. Stop. The case of the claimants before the learned trial court may be summed up thus. On 18/1/2018 at about 10:30 a.m., when the victim Sushanto Kumar Bhuiya was proceeding on foot towards Mohishadal side from Gopalpur stroke Nandakumar side, along with his extreme left side footpath portion of Holdia within inverted comma Mecheda inverted comma road, and when he reached near Gopalpur Bhattopukur Gopalpur Bhattopukur inverted comma মধ্যে under PS Mohishadal, then suddenly at the said time and on the said road and at said place, an offending bus bearing number WB33 capital B stroke 0213 coming with excessive speed, endangering to human life and safety from Mohishadal stroke Holdia within bracket within inverted comma side dashed the victim with great force. Stop. Next paragraph. As a result of the said accident, the victim was injured on his head and all over the body and sustained severe injuries and became senseless, and thereafter he was taken to Bashulia Rural Hospital at Bashulia, Mohishadal, Purbo Medinipur, and their doctor declared him dead. Stop. Postmortem was held at Holdia SD Hospital at Basudepur, Holdia, Purbo Medinipur. The said offending bus bearing WB33 capital B stroke 0213 was being driven rashly and negligently at a very high speed without blowing horn. Stop. The said accident occurred due to violation of traffic stroke road rules and negligence and rash driving of the bus bearing number WB33 capital B stroke 0213. Stop. The said vehicle was fully responsible for the pathetic accident. Stop. The victim was of 74 years of age, having sound health and good physique at the time of accident. Stop. The victim was kerosene oil dealer by profession. Stop. The victim used to earn rupees 6,000 average per month from his said business. Stop. After the accident, the said business was totally stopped. Full stop. Claimants depended for their living upon the victim when he was alive. Stop. Now they have no source of any income to maintain themselves. Stop. Pursuant to the claim petition being filed, notice was issued upon the opposite parties. Opposite party entered appearance and contested the case. Stop. The evidence was adduced and by judgment and award dated 31st August 2022, the Learned Trial Court was pleased to dispose the claim case by observing and directing as follows. এখানে লিখে দেবেন hence ordered. এই যে page 26. এখান থেকে গোটাটা। The claimant's appellants being aggrieved by the judgment and award passed by the Learned Trial Court has come up with the instant appeal. Stop. Hard learned advocate for the claimant's appellants and learned advocate for the respondent number 1, United India Insurance Company Limited. Produce the materials on record. Stop. Learned advocate for the appellant submits that the Learned Trial Court has not considered the income of the victim on the basis of evidence of PW2. The Inspector Food and Supplies, Mohishadol Block. Learned advocate draws attention to the deposition of PW2 and submits that as per his deposition, the victim being the authorized kerosene dealer used to receive SK oil from government, SK oil from government at rupees 28.94 per liter, and he was permitted the same at rupees 31.39 paise per liter. Stop. In the month of December 2017, the victim was allotted 3448 liters of SK oil for sale. Stop. Presently, the commission given to the authorized SK dealer is rupees 3.36 paise per liter. Learned advocate further submits that the learned tribunal ought to have considered the number of dependents and ought to have considered personal deduction of 1/4 and not 1/3. Learned advocate also submits that the compensation awarded should be enhanced. Learned advocate relies upon the following judicial decisions. Number 1, Sanjay Verma versus Haryana Roadways, reported in 2014 1 TSC 711 SC. Seema Rani and another versus Oriental Insurance Company Limited and others, reported in 2025 INSC 192. Kirti and another, etc. versus Oriental Insurance Company Limited, reported in 2021 SAR within bracket CIV 147, an unreported decision of this honorable court in the case of FMA 63 of 2025. Learned advocate appearing for the respondent number 1 insurance company draws attention to the materials on record and submits that the different allotments issued to the victim will go to show that the sale of every month was not uniform. Learned advocate further submits that considering variation of the income, learned judge rightly took the notional income of rupees 6,000. Thus, there should not be any enhancement. Learned advocate also submits that deduction of 1/3 on account of personal expenses is reasonable as some of the claimants were major and married. Upon hearing the learned advocates and considering the facts of the case and decisions relied upon, this court is of the view that as the Motor Accident Claim Tribunal has the duty to award just and reasonable compensation, mere claim petition of the claimants should not be considered merely for the purpose of assessing just and reasonable compensation. As motor accident claim legislation is a beneficial legislation, the courts and tribunals cannot be a mere umpire, but has to proceed to ascertain the truth, to do justice by awarding just and reasonable compensation. In the case of Rajesh and others versus Rajbir Singh and others, reported in 2014 within bracket WLRSC 23, the Honorable Supreme Court observed as follows. Set out para 10 and 11. ঠিক আছে? 10, 11 and 12. Folded page. Upon considering the allotment, considering the evidence of PW2, the Food and Supply Inspector, and the allotment made to the victim on different parts of the year, this court is of the view that although income may not be same for every month, as there is variation of sale, but it would be just and reasonable to consider the average sale of each month as rupees 3,000 at rupees 3.36 paisa per liter, and consider the monthly income to be rupees 10,000. In the event rupees 10,000 is considered to be the monthly income, in the facts and circumstances of the case, and considering that some of the claimants are major and married, it would be proper to deduct 1/3 on account of personal expenses. Upon deduction of 1/3 of personal expenses, the net monthly income comes to rupees 7,000 per month. The annual income comes to rupees 84,000 per month. Hence, the annual dependency loss is rupees 84,000. Stop. As the victim was 74 years old, multiplier of 5 should be applied, and the total dependency loss comes to rupees 4,20,000. As rupees 31,000 is awarded on account of loss of estate and funeral expenses, and the total consortium of rupees 2,64,000 by the learned trial court, and no cross objection is filed by the appellant insurance company, this court does not think fit to interfere with with the compensation on the heads of general loss and damages. Thus, the amount granted on account of loss of general heads, loss of compensation on account of general damages is considered to be heads, to be considered to be 2,97,000. Thus, the total compensation comes to rupees 7,17,000 by arithmetical calculation. However, this court is of the view that rupees 7 lakh compensation is just and reasonable. Thus, the appellant's claimants are entitled to compensation of rupees 7 lakh at the rate of along with interest at the rate of 6% per annum.
My lord, 5,37,000.
Okay, 6% per annum from the date of filing till today. The respondent number 1 insurance company shall deposit the rupees 7 lakh along with interest at the rate of 6% per annum from the date of filing till today within 8 weeks from the date of communication of this order. Stop. In the event the compensation awarded by the learned trial court is already deposited, the balance amount shall be deposited.
They withdrawn, my lord. They before the tribunal, they already.
Okay, I'm making the balance amount shall be deposited.
Yes.
The appellant's claimants are permitted to withdraw the amount deposited upon compliance of the necessary formalities.
Within 8 weeks.
কোথায় গেলাম? সেই কাগজটা যেটা করেছিলাম তৈরি, জাজমেন্টের কাগজটা এই যাই
Only three.
Yes, 3.
Yes, my lord. I am appealing for the appellant claimants, my lord.
This is for Calcutta State Transport Corporation.
Yes, my lord.
Anyway, I have to release this matter because when I was in deputation, I was the advisor of that institution. Calcutta CSTC. So I cannot take up this matter. Yes, record an order. As I have dealt with this matter while posted on deputation in Calcutta State Transport Corporation. The matter stands released on personal grounds. The matter be placed before the Honorable Chief Justice for necessary assignment.
কোনটাই খারাপ আমি তো অ্যাপিলেন্ট আছি
Yes, Lordship.
My lord, I am for the appellant insurance company.
Lordship, prior to placement of the Mr. Chakraborty, there is just two separate appeal arising out of common judgment. So I am also appellant, Mr. I am both are contesting same position. Yes, sir.
My lord, one appeal is 1061 and his appeal number is 6612.
612.
So separate appeals.
Separate appeal. They have preferred an appeal. We have also preferred.
Arising out of common judgment.
Common judgment, my lord.
Okay.
My lord, our grounds of appeal is on 4, page 3, my lord, in the paper book.
Page 48.
Page 48. Page 40 running, page 48, my lord. Inner page 3. We are agitating, my lord, before your lordship. The learned court, trial court has given 1,50,000 and rupees 2 lakhs towards pain and sufferings as award for the death case, which is excessive, according to us.
This is
Which is excessive, my lord.
injury case.
No, death case.
Death case.
How much is awarded?
Page 44. Page 44.
Page 40. Awarded is page 44. Nine lakhs 84,000 45.
Okay. 9 lakh?
9,84,000 with
Yes.
6% per annum interest.
Yes.
And my lord, this has been given. And also we have taken the grounds that is in page 49 that they have lost the FIR after 19 days. That is
Page
fine.
49.
Yes, 49, 48, 49.
Yes.
48 we have seen has not lost the FIR at KUD police station on accidental day, whereas the FIR was lost on 14/7/2020. There was a delay of 19 days in lodging the FIR without any reasonable explanation.
So when did the accident take place?
Accident took place, my lord. Let me see. 25/6/2020 at 5 AM.
25/6 or 26?
25/6.
Okay, 25/6.
25/6/2020. It took accident took place. Then, my lord, they have also prepared.
Okay, this is on the grounds of delay in FIR.
Delay in FIR and also the excessive pay.
Yes, excessive on what grounds?
Excessive on, my lord, page 44.
Yes.
That is,
We cannot deny.
we cannot deny, my lord. Question of income of the victim. In order to prove the same, the claimant have filed one certificate of fitness of vehicle number so and so, but it does not show that.
We cannot deny.
Then, my lord, here in the bottom, we cannot deny that there was future prospect of a person aged 46 years, and to the context, this tribunal wants to award 1,50,000 as well as 2 lakhs towards pain and sufferings. No explanation. Then the total income comes to so and so. So, my lord, we are ready to pay.
So
But
9,36,000 was awarded.
yes, ma'am.
No, 9,84,000.
84,000.
Future prospect was taken into consideration.
Yes.
Future prospect.
Yes. That is our ground, nothing else.
So your ground of challenge is delay in lodging the FIR?
FIR. No explanation. Lordship may kindly see the entire judgment. There is no explanation. And also in the evidence.
On the date of the accident, the death took place.
They took place. They took 19 days to file the FIR. Lordship knows that delay has to be explained.
Okay. So, future prospect, how much was taken into consideration?
Future prospect is taken, my lord.
May I assist future prospect according to Punashari Shola Verma, that
Yeah, no.
ratio not considered. Here a lump sum amount has been considered. So I am
Future prospect, what was his age?
46.
46.
Self-employed.
Self-employed.
So it should be 25%.
1,50,000 as well as 2 lakhs towards pain and
But
suffering.
the amount, the landowner considers 6,000. Let Mr. Chakraborty finish.
No, you should finish up.
So, Lordship, I have also prepared an appeal, the fresh appeal. And this both appeal as before your Lordship. So, prior to that, Lordship also.
The paper book itself.
Yes.
Two memo of appeal also annexed with the paper. Lordship, kindly, the 2 point as raised by Mr. Chakraborty, one is Lordship delay lodging FIR. Lordship, kindly come to page 43. The learned tribunal given a proper explanation to that effect. Lordship, kindly come to page 43, paragraph 4. You got it?
Paragraph 4, yes.
So there's no marking, but let's kindly see 1, 2, 3, 4 is well. PW2 has been examined in this case as eyewitness. Has you got it?
Yes.
Yes. So though the OP2 has tried its best to establish that he is an interested witness and come to the learned court on request of the claimant, they failed to do so because PW2 is named as categorically witness of the charge sheet of Khejuri police station such and such, dated such and such, which is a result of the accident in question. Otherwise, there is no adverse evidence on record. Claimant have been able to prove that Arun Giri, since this is suffered from the accidental death due to the accident, which is took place on 5 a.m. as 25 June 2020. The accident being taken place rash and negligent driving of the driver of the offending vehicle, and accordingly, Lordship, the tribunal come to a conclusion. And Lordship, charge is submitted, and he is the eyewitness is the charge sheeted witness. And Lordship, second issue is this. So I am partly supporting the appellant on the issue of quantum. Lordship, kindly come to page 44. You see, my humble submission is that Lordship, kindly come to page for the middle. Lordship will found he is the Lordship, he is the owner of the truck. Deceased is the owner of the truck. In support of his business, in support, he has produced the Lordship's certificate of registration. Lordship, kindly turn to page. You kindly turn to page. Turn to page 32.
Yes.
Deceased was it appears from the claim application, the avocation of the deceased, he is the transport business and he is the owner of the truck. And Lordship, in support of his averment, in support of his submission, the Lordship also placed one certificate of fitness. Lordship will found here he is the certificate of fitness. And Lordship also kindly see also that there is also place that the Arun Giri is the owner of the truck. So the person,
the victim,
not of offending vehicle. So the profession, he was the owner of the truck, and he's the truck name and the entire particulars of the truck has been given there. That has been exhibited. But Lordship, in spite of that, Lordship kindly turn to page 44 once again. Lordship, kindly pardon me, and page 44. His claimed Lordship is claimed that he's earning rupees 15,000 per month, but the learned tribunal considered 6,000 per month. Because of the, apart from that, they did not produce any document in support of his income. Lordship, my humble submission, oral evidence also one of the evidence. But Lordship, once the wife has come and stated that is you earning rupees 15,000 per month, but the learned tribunal kindly consider the observation of the learned tribunal is bad, according to me, Lordship, with respect to the judiciary. Lordship,
How much is the deposition?
15,000. Lordship, kindly turn to page evidence of the PW1. Page 10, paragraph 5. Paragraph 4, paragraph 5.
Page
10. Lordship, kindly see page 4, paragraph 4.
Yes.
That at the time of accident, my husband Arun Giri was aged about 46 years. He was owner of the truck number such and such, that the 31A3034 that will find from the page 32, and transport business, and he was on rupees 15,000 per month from this occupation, but after his accidental death, said business was stopped. So kindly that. So after that, business stopped. So now there no income. So income has been stopped. And this is true to my knowledge. And then paragraph 5, that at the time of accident, this is Arun Giri, was healthy young man, was active habit. At the time of accident, his income was 15,000 per month from business. That owner of truck number such and such is a transport business. Lordship, kindly, without setting the judicial hours, Lordship, kindly turn to page 12, page 12. There's a cross-examination. Let's kindly come to the cross-examination. Kindly see the exhibit 2, exhibit 3, exhibit 4. That is the certificate of seizure list, such and such, insurance, the certificate of fitness of the vehicle. That's exhibit 7 that I have shown from page 32, the certificate of fitness. Wherefrom it is proved that is the owner of the truck. That's the certificate of fitness has been exhibited. That's exhibit 7. So he's the owner of the truck, is the person having with the transport business. That's true. And also, in spite of that, the learned tribunal, so my appeal only issue of the quantum. Then also kindly turn to page 13. Fourth line, not a fact that monthly income of my husband was not 15,000 per month. Against that, no suggestion and no rebuttal evidence. It is not that the evidence should be within the very reasonable. So that reasonable. So accordingly, he's in all aspects. He said 15,000. So see, one the truck owner is if he not can usually can use to earn more than 15,000. Otherwise, he cannot provide the driver, provide the cleaner. So 15,000 is very reasonable. But the learned tribunal, considering that there is no certificate in this regard, so come to a conclusion 6,000. So you kindly come to the observation of the learned tribunal once again. Page 44.
Yes.
Second paragraph. Next comes question income of the victim. In order to prove the same, the claimant have filed one certificate of fitness of vehicle number such and such goods carrier, but does not show the name of the owner. Therefore, the tribunal is not positioned to conclude that this is Arun Giri, the owner of the vehicle. There is no document of earning. Tribunal will come to a conclusion 6,000 per notional income per month, calculating accordingly. So, Lordship, she is the owner of the opinion vehicle. So, kindly see that is the vehicle his name is appearing.
No. Have you exhibited?
Yes.
Why? Which page?
Page 32. Page 32. See that?
No. Vehicle, the name of the vehicle owner.
It is a certificate of fitness.
Where is the registered
name?
What is the registration certificate?
This is the permit registration certificate. Their name is appearing.
Where? Which? Yes. Where is this person's name?
Lordship, kindly see the evidence of the PW1.
Well, you see, where is the document showing that the vehicle is registered in this person's name? Any registration certificate?
Yes.
Where is the registration
Lordship,
certificate?
kindly see that there is a certificate that the
No. This is certificate of fitness of this vehicle. Okay. Where is that registration certificate?
Kindly see that the registration certificate permit and goods permit.
Where in your Where have you stated?
That document is not.
No. You have not given in your evidence.
Very well, Lordship. Very well, Lordship. Kindly.
So from which document can the court presume that?
Kindly, my humble submission in this regard. So the wife, the evidence is there. His husband is the transport business.
We don't know whether transport business or transport driver.
But Lordship, he said his income is the.
Question is, any document to show that he is the owner of this vehicle?
Lordship, only that document is 32. I'm very clear.
32 does not show that he is the owner of this vehicle.
32, that name is not appearing.
So how can you say that he is the name?
Kindly see the registration number.
No, maybe registration, but whose name it is?
It can be corroborated. Registration number. Lordship, can you see WB31?
Nobody, you see, no employer, no driver, nobody has come to depose. No, to depose that this person is doing business.
No, that's wife has come.
Wife is the, any third party. Wife is the interested witness. Any local person or the driver, Khalasi, whoever, nobody has come to depose.
I'm sorry. Lordship, in such a case, nobody will come on the request. Yes, come and say you are the driver of the vehicle.
Why you will not come? If you are
usually they are not coming.
Your local persons will know that this person has a vehicle and he does.
They will not come to the court for that purpose. It is the very common practice of our society.
No. If there's someone.
My humble submission is that
there's so many cases. There are third-party evidences.
There is there. If there is that the evidence is there, then we are.
These findings of the learned trial judge that the Arun Giri was owner of the vehicle cannot be faulted with.
Lordship, my humble submission on the evidence of the PW1, what is said, this is my husband.
Apart from PW1, you see, there are any other corroborative evidence.
I'm submitting. It appears from the evidence of the PW1, her husband used to earn 15,000 per month. Apart from that, avocation not proved. What is the avocation?
See, there are many ways to prove the income. One is the income tax return. The other is the bank account.
It is not come with the income tax return.
Okay, very well. Then there may be bank balance. Very well, forget everything. Yes. Only to show that he is doing this business, the registration certificate of the vehicle is sufficient.
My humble submission before your lordship, the wife has come and said that husband used to earn 15,000 per month. There is a oral evidence. See, if the oral evidence, what is the avocation? Kindly lordship, ignore that. But lordship, the evidence of the PW1, the husband used to earn 15,000 per month, can we consider, not consider? That is the basic issue. Lordship, in this juncture, lordship, I am placing my judgment over Calcutta High Court. The judgment delivered by Justice Dipongo Dotto. Now can we take as a Supreme Court judgment? Lordship, kindly come to this judgment.
Copy.
Yes, kindly see that. I have checked up. That name is not there. Lordship, kindly come. You are the one of the Lordship, kindly come to paragraph 15. Bottom. Has you got it?
Yes.
A different view is called for in terms of Section 3 of the Indian Evidence Act 1972. Evidence of two kinds, oral and documentary. All statement which the court permits is required to be made before by its witness in relation to the matters, the fact under the inquiry. That is the lordship's query. Now, oral evidence. The term proved in the same section read as follows. Proved, a fact is said to be proved when, after considering the matters before it, the court either believe it to exist or consider the existence so probable as a prudent man ought, and under the circumstances of the particular case, do act upon the supposition of the exist. Then lordship, kindly come to paragraph 18. We are of the considering view that the version of the claimant, and viewed in the light of the aforesaid provisions of the Evidence Act and the test preponderance and probability, it is not the improbable. The oral evidence of PW1 was in the conformity with the requirements of law and trustworthy, and did not suffer any inconsistency in contradiction, exaggeration, and embellishment. The burden of proof having been discharged upon the claimant, the owner shifted on the insurer. Let's you can mark this position. Owners shifted on the insurer. The insurer did not adduce an evidence to cast doubt in respect of the claim version that the claimant had earlier haircutting salon or barber. Here was the barber. As a barber, the victim ought to have earned rupees 2,200 per day. He had monthly income 6,000 per month, approximately is possible. So the figure 200 and 6,000 it is the issue. The issue of the ratio, what is the ratio decided by the Honorable Division Bench? That is the basic issue. The tribunal formed the opinion, the evidence of PW1 is Keidedorthi. We are thus unable to agree with the Mr. Singh that the tribunal committed an error proceeding in the permissible between
did PW1 state that he is the owner of this vehicle?
Yes.
No, in the evidence. Let us see.
Yes, evidence said.
Let us see in the evidence
Lordship.
that this vehicle
is
registered in the name of my husband.
Yes.
Let us see
4, page 10. That at the time of accident, my husband Arun Giri was 46 years old. He was owner of the truck number 3034. The wife said. Now, I have twofold submission before your lordship. One is that the PW1, the wife of the victim, has come and said his husband is the owner of the truck, and in support of his averments and submission, he placed the fitness certificate. And second fold of submission is that his wife said, my husband income is 15,000 per month. They did not produce any document in this regard. In support of that, I am producing judgment. The ratio of the judgment lordship will consider is our division bench judgment. Then lordship, lordship kindly see the word used by the learned our High Court. If the inconsistency, the 15,000 inconsistency, 15,000 contradiction.
Now the question is, you see, the best evidence could have been produced by you, that registration certificate.
Yes.
Because best evidence was in your hand.
Yes.
If you can produce this certificate of fitness, you can produce that also.
Yes, lordship. For that reason, my humble submission, if lordship kindly ignore that part, only take it on part that his income is 15,000 per month. That part, I am not able to produce the whatever that is in the evidence. That's why I have, from my side, I have placed this document of page 32. That is the fitness certificate. But lordship,
question is, shall I remit the matter back to tribunal to submit this registration certificate?
What will happen, lordship?
No. So that the question of compensation can be considered.
Avocation.
Yes. First of all, the ownership of the vehicle is not proved. Otherwise, you can do one thing. If you want, you can file an affidavit enclosing this registration certificate of this vehicle. Let us consider that.
That certificate I will produce. Kindly for satisfaction.
No, if you want to produce, I can grant you that opportunity. Otherwise, if you want the court to proceed, whatever is the materials on record, I can do. If you can produce it, well and good. File an affidavit. That this is the.
Very well, lordship. I will file additional evidence or 4157.
No, file an affidavit.
Just only affidavit I will file that. Very well, lordship. Kindly adjourn for a week.
And let them take instruction, let them verify.
Yes, lordship.
Yes, record and order. Learned advocates for the parties are present. Are learned advocates. Learned advocates for the appellant is granted opportunity to file an affidavit with regard to the ownership of the victim of vehicle of a particular vehicle.
Number?
Yes, WB31 capital A 3034 from the appropriate authority.
From the appropriate authority, Maryland?
From the Motor Vehicles Authority, you can take this information.
Information I have, only I have to file with the affidavit.
No. This ownership of this person, victim.
Yes, that authority I have.
No. This is the registration certificate.
Yes.
Okay, let me see that.
Kindly see that. See, there is the original, but somehow they have not able to place. Kindly see the Arun Giri name is appearing.
Okay, this is the registration.
Kindly see
it's better you are filing it at this virgin, so better file an affidavit.
Yes, Lord.
Okay, keep this original with you. serve a copy of this affidavit. Yes, file an affidavit.
Authority, that part kindly deleted.
Acha, authority ta kete din, huh? Let this matter appear on আচ্ছা ইয়েতে দেখুন তো 18 তারিখে 4টের সময় কিছু আছে?
বলনা 3টেতে রাখতে 4টে
Okay, 18 to 2026
3 p.m.
at 4 p.m.
Oh, 3 p.m. I believe
3টের সময় আছে কিছু দেখুন তো? You see, 3 p.m. I have to keep some matter. This will not take much time.
No.
Half an hour is sufficient.
More less
By
than that,
keep
because-
3 p.m. I cannot keep other matters at 3 p.m. আর 3টের সময় আছে ওদিন 18 তারিখে?
নেই 3 p.m.
নেই। আচ্ছা 18 to 2026 at 3 p.m.
Lots.
Yes, keep this with you.
Lots. Just I'll file this document by your affidavit.
Yes.
I'm okay.
Time for the application. This is in the appeal, my lord, challenging.
You are the appellant. Yes. What are the grounds of appeal?
Grounds, my lord, that the victim deceased died in a COVID positive.
Yes.
COVID. Medical report is my lord, here also kindly see my lord. Medical report, my lord, page 37, my lord. Page 37, my lord, medical report, my lord.
Death certificate.
Yes.
Or death certificate.
Uh.
Death certificate, my lord, COVID respiratory failure. CKD, sepsis, COVID, pneumonia plus RTA. मतलब CKD मतलब meanings मतलब a long-standing disease of the kidney leading to a renal failure. So मतलब he is suffering from kidney मतलब he is suffering from COVID positive मतलब. मतलब sepsis means मतलब
7/7 he was admitted and expired on 13/7.
Yes. 7/7 malab the date of accident.
And died on 13/7.
Yes. Accident took place during COVID period. Not yet.
My FIR was lodged after 27 days. No FIR has been received by the police. Then he filed an application under section 156, subsection.
FIR was filed after the death or after the accident?
No, after death. After death he filed.
Prior to death, prior to accident, death, no FIR was filed.
No, my lord. That they filed 156 CRPC. The magistrate direction made to the police officer for investigation and one in connivance with the police and claimant that has been involved that alleged offending vehicle
তাহলে একটা চিঠি করে নিয়ে আসবে কালকে হ্যাঁ তাহলে একটা চিঠি করে নিয়ে আসতে হবে
no postmortem report but no eyewitness.
This is just under section 160 164 that is no for liability.
No, they have to prove that accident.
ঠিক আছে নিন না আছে আছে
No, is there anything in the record to show from the hospital authorities report that the admission was due to RTA?
Plus RTA, but no nature of.
No, RTA, any admission was there recorded? RTA.
yes plus RTA my lord
Which page?
37 page
Page?
37 itself my lord said so RTA my lord kindly
What
see
type of injury has not mentioned, my lord?
my lord that is the impact of the injury my lord
Okay, RTA is there.
RTA is there my lord kindly see for a moment my lord last pneumonia COVID pneumonia plus RTA
No, that means she was admitted 7/7/2021 to 13/7.
RTA. Due to RTA.
Oh, RTA is there mentioned.
Yes, RTA is there. Due to RTA, my lord.
And after the death, FIR was lodged. After how many days?
After 27 days, after 27 days.
That is not, my lord, much more. And Robi versus Bodhinaran has been considered by the landed tribunal below also. Insurance company also raised one question that the PM has not been done. My lord, that at that time, my lord, no PM has been done by the government concern also. My lord, let him submit. I shall submit after that. Actually, PM is not required to prove this case. I shall come before your lordship. এটা কি হ্যাঁ জাজমেন্টটা করুন
Yes.
Is মানে FIR মানে এটা হচ্ছে FIR মানে পেজ 31 ফলে দরখাস্তকারীর পিতা সাইকেল হইতে পড়িয়া যাইয়া গুরুতর রক্তাক্ত জখম হয় সঙ্গে সঙ্গে স্থানীয় লোকজন ন্যাশনাল হাইওয়েতে প্রহরারত পুলিশ 10 খাইতে পিতাকে উদ্ধার করে রায়গঞ্জ হাসপাতালে ভর্তি করে। হিয়ার মালা দি স্থানীয় লোকজন মানে লোকাল পিপুল অ্যান্ড মালা পুলিশ transferred to the hospital but none come forward to the witness box to prove that the accident মালা। স্থানীয় লোকজন
Charge sheet has been submitted. Enterটা বলুন my lord 30 page from 30 my lord starting from 30 my lord.
ভাই
My lord why my lord he has been fell down from the cycle. What happened? What was happened? That has been my lord submitted before your lordship by the insurance company, affiliate insurance company.
Oh, this is 156.3.
Yes, this is 156.3. This is 156.3. And thereafter, my lord, charge sheet has been submitted.
Oh, insurance company adduced any evidence?
Yes, OPW1
Yes, ma'am.
investigator.
Yes,
OPW1
Yes, ma'am.
investigator, my lord.
page.
page মালা your lordship 51 মালা 51 মালা lower portion of the
Yes.
ও না
One.
আপনার ওটা তো এভিডেন্সে যাচ্ছে
Yes, my lord.
my lord page 9 at first my lord kindly see the deposition page 9
9 তো 11 নয় এই 9 কোথায় পাবে
page 9 deposition of OPW1
I mean, report of the investigator my lord.
yeah that is report of the investigator
No, question is examination.
examination page 9
page 9 my lord.
Page
Nine.
9. Yes.
Your lordship can cross examination my lord, for that
বলো তো কি আছে মামলা চলছে আপনাকে কি মামলা চলছে এগুলো তো আছে
Yes, that is there.
yes my lord. Your lordship can say report of the investigator my lord.
yes page 45 from page 45 your lordship will find my lord investigation report starting from page 43 starting from page 43 কি বললো my lord page
Your lordship
45
kindly see from the page 51 my lord, opinion of the investigator my lord.
during investigation my lord the part 2 page 45
Opinion daily দিতে হবে, কি আছে?
page 45 what is
During the course of investigation, I visited the PO as per version of the eyewitness,
yes
namely Manav Das, they have come forward as a witness, madam. Manav Das and identified the place of accident. They told me on the date of the accident, the victim was returning home after finishing his work, riding his bicycle. And when he reached near Sohara More, at that time, the offending motorcycle being number such and such, coming with a high speed and rash and negligent manner, and all on a sudden came to a wrong side and struck the eyewitness of the victim. As a result, the victim received severe injuries and nearly persons along with police of highway patrol taken him to Raiganj Government Medical College and Hospital and admitted there. On during treatment, he was also got COVID affected and succumbed to his injury.
Thereafter, my lord, FIR is true.
So this is your investigation, not investigation by the police.
It is not the statement of the investigator.
Your investigating authority inquiry officer went to ascertain the truth. So he found all these things. Okay.
And
It is not that the claimant's inquiry officer or the police authority went. It is from your inspection, your inquiry.
The statement of the local police.
Yes, that
It
means
is not my statement, the investigator statement is
very
not.
well. That means in order to ascertain the facts, that means they, in order to satisfy themselves, went to the spot. So they got some statement. It's not that the people of the locality does not know anything about accident. Totally, they are in the dark. Something they have heard.
But they are not the witness of this claim case.
Very well, they may not be witness, but you, your authority, your officer went to the spot. So your officer was satisfied that something has taken place, accident has taken place.
Can you see the opinion of the investigator on page 51, madam?
You see, because you see, it is your inquiry.
Opinion
Your
of the-
inquiry officer went and inquired.
As
It's
my-
not that claimant's inquiry officer or police authority have went.
Madam, he
For your
died,
satisfaction, you went.
COVID positive, madam, death certificate.
But accident, regarding accident, your inquiry officer found. Can you disbelieve your own inquiry?
They has not stated that he died in the motor
Some
accident.
accident
That
took
is
place. Accident and admission. Okay.
Actually, as per my investigation and all points, I perused and all points, I perused that. The A
Which
part
page?
is
Page 51.
51.
Oh.
B, lower portion, madam. Paragraph 1. As per my investigation and all points, I perused and all points I perused that the AFR is delayed 27 days from the date of accident. So the involvement of the insured vehicle bearing number such and such was suspicious. Involvement of the said
When suspicion is there,
the time of
the
the
purpose of inquiry is followed. That is inquiry to ascertain some suspicion.
At the time,
See.
two, at the time of death of the victim was COVID affected person. So it cannot be clarified that the victim was died due because of the accident.
Anyway, it is his opinion. It is his personal opinion. But inquiry he conducted.
Yes, my lord.
That inquiry, that deposition is given.
It's not that he has.
The legal, not the.
You see, it is your officer who went and found that an accident took place. How can you disbelieve your own inquiry?
So whatever stated the local police, that has been mentioned here, madam. That is the investigation report.
Because you see, local police persons may say many things before police, okay, or may not say. But to your officer or inquiry officers, people will say yes with faith or something. Because your inquiry officer will not be misled.
Who said whatever stated, madam, in his claim petition, whatever stated, that has been stated here, madam.
Because it is your officer, not that it is manipulated.
For a moment, page 45. Page 45.
Another, I am showing you judgment only. Why he died in COVID, madam. Death certificate, you also can see COVID plus RTA. But what type of injury has not made, that has been not
But you see,
clarify here, madam.
that
You are also on judgment, madam, of the Madhya Pradesh High Court, madam. 3 judges bench, madam. Here, madam, you will also kindly see paragraph 10, madam.
your inquiry makes the case stronger. for the
Paragraph 10,
claimant.
madam.
ওটা কি কবে বেরিয়েছে বলুন এটা
2007
2007
2007 volume 2 TSC 71.
Yes, which page?
Page nahi, paragraph 10 mala. Yes.
Yes.
Paragraph 10, page mala 75.
Yes.
পেজটা বলুন ওটা
72, এই 71
71 thank you.
Section mala 36 of the.
No, no, is it with Motor Vehicles Act? Yes. Only with regard to succession. But it has to do with.
For he died in other personal injury, but not
No, no,
causes
was
the
the-
death of the party. But injury had maybe happened, but not causes the death of injury, my lord.
No, no, case. What was the subject matter of dispute? Para 50. Yeah.
হ্যাঁ, 2007 volume 2 TSC 71 COVID নয়।
So this is, we are of the considered opinion that a claim for personal injury filed under section 166 of the Motor Vehicles Act 1988 would abate on the death of the claimant and would not survive to his legal representatives, except as regards to claim for pecuniary loss to the estate of the claimant. So this is the issue.
My lord, that has been turned down by the honorable appellate
Yes,
chief
yes, there are
justice.
different other decisions.
Khalon is different. And your lordship has passed order also, considering Khalon.
Well, he is not died due to injury, my lord, due to COVID, my lord. That's why, my lord, that judgment I mean, citing, my lord.
That is the impact of the accident, my
Paragraph
lord.
10
And
of the.
I shall place before your lordship. কি বলছেন বলুন, তারপর আমি দেখছি।
Yes, I have considered. So any other documents?
No, my lord.
Yes, what do you say?
Yes, my lord, FIR is true. My lord, page 45, my lord, kindly see for a moment. They are document description of occurrence accident as per FIR and other sources. FIR is true. That has been admitted by the investigator, OPW1. If my lord, FIR is not true, then that can be fake. FIR is fake. My lord, kindly see landed tribunal what, my lord, has been dealt with. My lord, page 16 of the paper book. My lord, starting at the time of argument, learned advocate for the claimant submitted that the petitioner, through the evidence of PW1 and by submitting all other relevant documents, Exhibit 1 to 8, have successfully proved the death of Chandan Dotto due to road traffic accident, and as per Section 164 MB Act, they are entitled to get the compensation as paid for. On the contrary, learned counsel for the OP number 2 insurance company argued that as per the report of the investigator Exhibit A appointed by insurance company to investigate this matter, the FIR of the alleged incident was lodged after 7 days from the date of accident, and such unexplained delay had created suspicion on the involvement of the insured vehicle bearing number such and such. The alleged accident, learned advocate further argued that at the time of death, the victim was a COVID-affected person. It cannot be said undoubtedly that the said victim had died because of the alleged accident, but it might be possible that his death had occurred due to COVID and other physical complications, as mentioned in the death certificate. According to submission, London lawyer of the OP number 2, the petitioner failed to prove documents regarding treatment of the victim of this case, who was admitted the hospital from 7/7/2021 to 13/7/2021. The PM report of Chandan Dotto and proof regarding income of the victim that at the time of his death, it was alleged by the learned counsel that though only the wife of the deceased was dependent upon the victim at the time of alleged accident, the name of other two petitioners were inserted in the claim application to mislead the court, and thus the petitioner did not come before the court in clean hand. For such reasons, their claim should be rejected. Learned counsel for the insurance company raised vehement objection against the claim of the petitioner on the point that death of the Chandan Dotto had occurred due to road traffic accident RTA. It was submitted by the learned advocate that an application under section 164 MB Act, the petitioner are bound to submit PM report of the deceased in case of death of the victim, and only in absence of the same, the court can rely upon death certificate. But in the case in hand, the reasons shown by the petitioner for not having the PM report on the deceased is quite hard to believe, as when the alleged accident had happened, that is on such and such days, restrictions for COVID pandemic had been removed, and overall situation within the state became normalized. It was further argued by the learned advocate for the OP insurance company that as per the death certificate of the victim, the cause of his death were cardiac respiratory failure, CKD plus sepsis plus COVID pneumonia and RTA, and the petitioner did not take any endeavor to prove it before the court that among all those reasons, RTA was the prime factor of the death of the victim. Learned counsel for state such and such. Thereafter, my lord, kindly see. Thereafter, my lord, kindly see that page 17, my lord, bottom portion. It is well settled that delay in lodging FIR cannot be a ground to doubt the claimant's case, knowing that Indian conditions as they are, we cannot expect a common man to first rush to the police station immediately after an accident. Human nature and family responsibilities occupy the mind of kith and kin to such an extent that they give more importance to get the victim treated.
No, that is there. Now the question is with regard to the cause of death, any which paragraph it is dealt with.
My lord, dealt. And thereafter, my lord, page 18, my lord, OPW 1 has been admitted, the accident that has been, my lord, dealt with. Thereafter, my lord, page 19, my lord, middle portion. From middle portion that has been dealt with by the tribunal below. And it is fact that your lordship will find from the motor vehicle rules, my lord, I am placing before your lordship. এটাও তো মোটর ভেহিকলস একটাই না একটাই রুল এসছে দেখো শুধু এই ওয়ার্ডটা লিখতে পারি 29 my lord, kindly see, this is a case under section 160 to 164, my lord, that is no fault liability. And my lord, kindly see 329 rule. Actually, my lord, the PM is not mandatory. PM or death, 329, 330. 329, 330. Only one book is with me, my lord. There, my lord, has been written either PM or death certificate. 330 is, my lord, regarding no fault liability, 140. Same, my lord. This is first one. Another, my lord, the accident has been happened, and due to accident, he, my lord, admitted in the hospital. That is the impact. That is the impact of that accident. My lord, your lordship will find, my lord, kindly see, my lord, page, my lord, 164 section.
Okay, continue on the next day.
My lord. Continuation.
I guess, my lord, I have a humble prayer, my lord.
Yes.
Item number 20, your lordship passing on, my lord.
The learned advocates for the parties are present. Our learned advocates, let this matter be treated as heard in part and let it appear on 16
16.
16.
16.
2/2026
Stop, my lord.
at 10:30 a.m. Yes.
My lord, item number 28 of your lordship today's list, my lord.
Yes.
I am facing the execution stage of, in spite of a lordship specific direction that we have to sought for adjournment before the court below, but the court below has fixed the date. My lord, kindly
Let me see this.
my lord, can I think to 16th has been fixed for the execution of read by the police help. My lord, can I think to kindly fix it
দেখি কি বলছে
tomorrow at 10:30, my lord. Otherwise, my lord, my appeal will become infructuous, my lord.
So it's better you serve notice and mention tomorrow. Mention at 2 p.m.
Mention at 2 p.m.
Yes, serve
Mark.
notice and mention at 2 p.m.
I will, my lord. Grateful to you.
So item 7 is your matter.
Yes, Your Lordship.
Amen. Other side is also here.
For the Union of India.
Today is your turn to make submission.
Yes, Your Lordship.
Yes, what are your submissions?
Lordship, if Your Lordship kindly takes page 7, the judgment of the Railway Claims Tribunal, Your Lordship. Lordship, on page 10, paragraph 6.4. Lordship has the paper book.
No. Today the file will not be put up. Anyway, court officers are not here.
Oh.
So anyway, whatever you submit, I'll take it down.
Very well, Your Lordship. So the evidence.
May I please give it?
এটা দিন তো পেপার
একটু দিন
I'm grateful to my learned friend.
পেনটা বের করে দাও। এই যে এই যে ট্রেন এই ওটা লাইন টানা আছে দাগ দেওয়া আছে।
Lordship sees the 4th line at page 10. The findings of the police officer on the inquest report, which is a primary report, are found entirely based on the statements of the said witnesses. The applicant to substantiate her case has miserably failed to produce.
Para 6.4.
Your Lordship, before 6.4, I'm reading from the 4th line of.
The applicant to substantiate.
Yes. The applicant to substantiate her case has miserably failed to produce and examine them as eyewitnesses to the incident. In the post-mortem report, the doctor has opined that death was due to shock and hemorrhage, which resulted from ante-mortem injuries and seemed to be accidental in nature. Now, Krishnanagar GRPS closed the case so-and-so dated 25th July 2010 and submitted the final report. Krishnanagar GRPS has specifically mentioned in the final report that it was accidental in nature. Apart from fall from a running train, railway accident includes trespassing, knockdown, run over, etc. Therefore, in absence of any specific cause of death of the victim in the final report, it cannot be held that the husband of the applicant accidentally fell from a running train and died. As per the inquest report, one railway ticket was recovered from the possession of the deceased. It is pertinent to mention that mere recovery of a ticket does not establish that the deceased accidentally fell from a running train. Evidence of the applicant is self-serving. Applicant has not produced the alleged eyewitnesses Binoy Haldar and Somnath Haldar and examined them. There is no cogent evidence furnished on behalf of the applicant, which establishes that her husband fell from a train and succumbed to his injuries. No doubt that the Railway Claims Tribunal Act is a beneficial legislation. However, there is hardly any scope of taking deviation or departure from clear, unambiguous provisions of the Act. There is absolutely no evidence to ascertain the cause of death of the applicant's husband was due to fall from a running train. Tribunal must pay an obedience to the provisions of law and cannot grant claims in disregardful of law. It is the duty of the court awarding compensation from public fund to award strictly as per the compensation rules of 1990, and undue leniency needs to be avoided. Your Lordship, if Your Lordship turns to the next.
Recovered from these victims' possession or body. Ticket was recovered.
Ticket was recovered, but it does not show because the eyewitnesses were also not produced, Your Lordship.
No, but
Somnath Hall.
Accident was proved.
But accident can be due to various reasons.
Yes,
it
but
could be knocked down, it could be run over.
No, the place where the body was found is this, I think, far from the place of the residence of this person. Body recovered from which place?
Krishnagar.
No, and the residence of this person?
No, residence is Murshidabad and body recovered at Krishnagar.
And
Within
ticket
Bad-
also,
within
ticket
Bad-
also recovered from his
within
possession.
the railway line.
No, it was a reserved
So
compartment.
it says that the petitions the petitioner's case is that it was in between Krishnanagar City Junction and Badkula railway station.
Okay, between Krishnanagar and
Yes,
okay.
yes.
And not near the platform or something.
Within the line, within the rail line, not platform.
No,
He-
within
he fell
the
down within the running
between
train.
one station to another station.
Within the middle of the station.
Okay.
He
And
actually-
ticket means it's a general ticket, not reserved ticket.
General ticket.
General ticket of what? EMU or
No,
any other
local
express?
passenger train. Sialda.
Which
Algola Sialda.
Yes,
no, in
yes.
passenger train there will be no mention of the train.
No, second
Yes.
class ticket.
Okay,
Yes.
but in only reserved
So,
cases,
It has not been established
no ticket
by.
recovered is a passenger train.
And that was seized.
Yes, it is of
That
a
was seized
passenger.
by the police.
Now, Your Lordship, the claimant failed to produce any eyewitnesses mentioned in the claim application before the learned tribunal for any
No,
examination.
but report,
And
what does the report say?
The
Of the railway authority and the police authority?
I will paste that, Your
No,
Lordship.
let us submit.
Final report.
Yes.
You may please read it.
Page 24.
It starts from 24A, Your
This is
Lordship.
final report of the police.
Your Lordship, there's a handwritten part on 25, and then I come to 25A, Your Lordship. 25A says, during inquiry, I came to know from the passenger Binoy Haldar, who's son of so-and-so, and Shomnath Haldar, son of so-and-so, that they were I took up photo over the dead body in presence of witnesses and sent the dead body to Krishnanagar Hospital for PM examination to know the actual cause of death, and directed Netajuddin Sheikh with all connected papers of report DMO. During inquiry, it was learned by me that the deceased had fallen down from DN 112 Lalgola passenger train at about 1:15 hours. Also seized one railway ticket from BPS RS to Barakpur RS.
Okay.
Now,
the ticket
it
was
could,
from which
yes.
station?
Now, the ticket was from BPS RS to Barakpur RS.
BPS means
Baharampur Court.
Baharampur Court.
Now, Your Lordship, I can have any ticket in my pocket, Your Lordship.
Yes, for fun also. Just
No,
for fun,
if I have,
can
no, if
purchase
I
the
have
ticket.
traveled,
No,
if
just
I
for
have
fun, I
traveled the
can.
previous day,
No, previous day, you see.
Hmm.
Question is previous day, a person can travel and keep the ticket.
Yes.
But in which place it was found? Is it near the platform? Not near the platform.
not near the platform, Your Lordship.
So ticket, Baharampur Court to Barakpur.
Yes, Your Lordship. Now, received PM number 774.
Ticket dated when?
As
Listen, dated 24/7/10.
Okay, 24/7/10 is the ticket. Date
Yes.
Ticket.
Accident happened on 25.
no, accident.
2010, date of the ticket.
Ah.
Okay, date timings is also there.
Page
Yes.
28.
Yes.
My lord, page
So,
28.
so there's no correlation.
That is the date of the ticket.
Inquest report. In the inquest.
20A, Your Lordship, kindly takes.
8.
20A.
20.
20A.
Yeah. 20A, Your Lordship. Third last paragraph. The date of the ticket. H08083178103178. Dated 24/7/10.
That was Sunday.
And Your Lordship,
So the date is 24/7/10. Okay. And the date of recovery of the body?
25.
25th, Your Lordship, is when it happened. Now, this train was going between Krishnanagar and Badkula, and the ticket that he had was BPS to Barakpur
BPS to Barakpur.
of the previous day.
No, the train. Okay. The question is this person's body was found long after the train has passed. But
Yeah,
the
yeah.
question is,
After 2 and
no, the question is
2.5 hours.
24/7/2010 is the date of the ticket.
Yeah.
25/7/2010 body recovered.
Correct. Now, Your Lordship, if Your Lordship comes back to the inquiry report, 25A, last paragraph, received PM number 774/10, 25th July 2010 from Krishnanagar Hospital, Dr. Ajit Kumar Bishash's
25A.
Yes, 25A.
Yes, 25A.
Last paragraph. Dr. Ajit Kumar Bishash's report death is due to shock and hemorrhage resulting from above mentioned injuries, which are anti-mortem and seem to be accidental in nature. I consult with OC. He suggests me to submit FRP over this case. There is no foul play behind death and it's an accidental case. So I FRP over this case. Now, there is no correlation, one, between the ticket and where he has fallen down. The route is different. That's number one. Number two is that the claimant failed to prove the identity of the alleged victim. She could not produce the eyewitnesses at the time of exam.
Body was identified.
Body was identified, but she could not
Bring any witness to
bring any eyewitnesses. Third, Your Lordship, date of incident 25th of July, separate route. Now, claimant in her appeal, Your Lordship, has claimed 8 lakhs with 10% interest from the date of incident. This is totally in contravention to the rules and violation of the Supreme Court's judgment.
You know, how much is the statutory amount? Which
Your
is
Lordship,
payable?
the Supreme Court,
No, what is the statutory amount?
I'm placing before Your Lordship. If the death in an accident occurred before the amendment, Your Lordship, it would be 4 lakhs. If after applying reasonable rate of interest were to be less than 8 lakhs, which was brought in a way by amendment, the claimant would be entitled to rupees 8 lakhs. If, however, the amount of original compensation with rate of interest were to exceed the sum of 8 lakhs, then the compensation would be in terms of figure in excess of 8 lakhs. So, post amendment, Your Lordship, she has claimed.
So anyway, the tribunal will grant just and reasonable compensation, what is provided under the statute. Maybe she
As
has
per the
claimed,
compensation rules of
yes,
99.
it's not that whatever she has claimed, that has to be followed.
And Your Lordship, the issue in the tribunal, what fell from the tribunal was whether the victim died in an untoward incident as defined under section 123C2 of the Railways Act. But they were not able to answer that in the affirmative.
Whatever is, you see, these are the evidence from the report of the authorities. It is very difficult to collect witnesses. The claimant can't go and collect witness.
So they have clearly said in page 11.
From the evidence of the report, prima facie, it appears to the tribunal is empowered to grant compensation.
Your Lordship, page 11, if Your Lordship sees.
Yes.
This is regarding the issue whether the victim died in an untoward incident as defined under section 123C2 of the Railways Act of 1989. Issue is answered against the applicant and the case of the applicant doesn't come under the purview of 123C2 of Railways Act.
Anyway, considering the evidence.
Yes. Because no nexus could be shown, Your Lordship. The ticket is different. Eyewitnesses could not be produced.
It is different means ticket is found from his possession.
Yes, but it
That
is
means
for a different.
he had a valid ticket.
He had
a valid ticket to travel by train.
But
okay, that is not. He had a valid ticket, and the date of the ticket is 24/7.
Yes,
it's not that long after the accident this ticket is found. On the following day, the body is recovered.
Yes, Your Lordship, but if it is Shialda to its BPS to Barrackpur, Your Lordship, and it is recovered on a completely different route the next day, Your Lordship, then Your Lordship.
In between, is it not between the two stations? From Baharampur to this.
Baharampur to Barak.
Barakpur.
So BPS is sorry,
Actually, mostly my lord, my learned friend,
In between the stations, the body was.
actually had no proper idea about running of the trains.
Ticket, you see
And
the
on
date.
that line, train was started from Lalgola, and that was coming from Lalgola to Sialda. And that was the time, night time, 11, if I not just error in it, 11:25.
No, the
11:20 night
starting
times.
time. That is the
Yeah,
starting time.
and after Baharampur to Krishnagod, it takes 2.5 hours. Because he is the
That is why you see the ticket.
he
that is
purchased on 24,
Yes.
but he accidentally fell down in 25.
No, body found.
Body found. He actually fell down in 25 also, my lord.
Whatever
Because
it is.
25th.
actually he started 12 hours night. And if 12 hours it comes in date change.
Or he purchased the ticket at 11.
Yeah, 10:30 or 10:45. Because train now started most probably Baharampur 11:45.
That is why you see this is to be ascertained. The time, the body found, and the date of purchase of the ticket.
After 2 or 3 years, within that period, the date has been changed.
And that was not a reserved ticket, it was the general
ticket. And Shivaratri was there, he was coming to pour water on the Lord Shiva. That was Sunday. And he put on Monday. And all of the, most probably you go through that, he was with Gerua wearings. That was actually he wearings for pouring water on the Lord Shiva. And Lord, she has not gone to
Anyway, let her complete. Thereafter you reply.
Yes, Your Lordship. Now, Your Lordship, if Your Lordship takes page 2A, that is the petitioner's application to the claims tribunal. She alleges in the last paragraph on the right side, Your Lordship, paragraph 6. On 25/7/10, her husband, Amrit Pramanik, now one place she has put the name as Amrit Pramanik, Your Lordship. I will come to this. Was traveling from Behrampur to Sialda to fetch Ganga Jal on the head of Lord Shiva from so-and-so place, having a valid second-class railway ticket. Due to overcrowded pressure and sudden jerk, he accidentally fell from the running train between Krishnanagar and Badkula station and died on the spot. Now, Binoy Haldar and Somnath Haldar saw the incident. Police case was registered at Krishnanagar on so-and-so date. Next, Your Lordship, she has given the details of the family members, the address, and the bank account. And she says that a second class valid railway ticket was found. Now, after having seen this, if Your Lordship comes to the judgment, Your Lordship. Now, paragraph 5, page 8. Learned counsel for the respondent had submitted that in the claim application, the name of the victim is, because I had pointed out, Your Lordship, Amrit Pramanik. Whereas, in the police reports, post-mortem report, the name of the applicant's husband is written as Amrita Pramanik. And there is proof on record that both Amrit Pramanik and Amrita Pramanik are the same person. The applicant has not produced and examined the alleged eyewitnesses, namely so-and-so. There is no FIR on record, And in the inquest report, there is no mention of any FIR. Applicant has not furnished any railway journey ticket of the victim to prove his bona fide, and there is no seizure list also.
No, you see, ticket was recovered by the authority from the body. The ticket was not in the custody of the applicant. So no question of the applicant producing the ticket. Whatever the authority has collected, that will be a matter of the record.
Very well, I bow down before your lordship. But your lordship, there was no seizure list also.
Okay. Anyway, so this document railway ticket was before the tribunal and it was exhibited also.
If your lordship sees
No,
the
my
claim
lord,
application,
this is the point. Actually, tribunal did not ask the police report or police evidence.
No,
The ticket was in the seizure list of police that was seized by the police authority.
it says, your
was in the
lordship, it
police
says
authority.
clearly on page 10.
Tribunal,
Page 10, before 6.4 starts, the last paragraph. As per the inquest report, one railway ticket was recovered
So
from the
that is
possession.
there.
Yes, your lordship.
Inquest report.
But it says that it is pertinent to mention that mere recovery of a ticket does not establish that the
Yes, yes,
deceased.
the other evidence has to be considered
Yes.
very well.
Yes, your
So
lordship.
that is why evidence ticket, which date and everything.
Yes, your lordship.
So that from the ticket itself, the date was established. Date of
It was
issuance
the
of
previous
ticket.
date.
Yes, yes, previous date.
Previous date.
The day on which the body was recovered.
Yes. Because the death happened on 25th.
No, that will be available from the postmortem report. You see, the time of the death.
Yes.
But the body was found on the following day when the date of the ticket was issued.
Yeah.
In the daylight.
Your lordship sees page 25A once again. So they received the postmortem on 25th July itself. Because it was learned by the officer that the deceased fell down from the Lalgola passenger train at about 1:15 hours in the night. Lordship can see the postmortem report also at 19A, your lordship.
It was done on 25th.
Yes, your lordship. The fourth column, second and third row. Dispatch was at 8:30 hours in the morning. Examination at 1:45. And nobody knows, Your Lordship, as per 124A of the Railways Act, Your Lordship, it says, the proviso to that section says, provided that no compensation shall be payable under this section by the railway administration if the passenger dies or suffers injury due to suicide or attempted suicide by him, self-inflicted injury, his own criminal act, any act omitted by him in a state of intoxication or insanity, committed by him, sorry, there's some typographical error, any natural cause or disease or medical or surgical treatment unless such treatment becomes necessary due to injury caused by the said untoward incident. Now, Your Lordship, the onus of proving that it was not one of these, Your Lordship, was on the applicant, and she was not able to satisfy the Railway Claims Tribunal, Your Lordship, vis-a-vis this section. There's no way of knowing whether this was an attempted suicide or whether it was a self-inflicted injury or whether he was intoxicated or insane.
See, that is for the police authority to find out from the evidence. There is no question of proceeding with suspicion that it could have been. Whatever is there on the record, tribunal has to
I
proceed
bow
on
down
that.
before Your Lordship, but the claim, the tribunal has taken note of it.
Contrary evidence by the railway authority that there was he was due to he was toxic or some other thing. That is in absence of other evidence, contrary evidence, why the tribunal will proceed that it could have been something.
That is the question.
However, the fact, Your Lordship, that he has fallen from a running train, that has not been established.
Yes, anything else?
Lordship, the judgment that I wanted to cite, if Your Lordship takes the citation.
You have a copy?
I don't have a copy right now, but I can.
Give with your written notes of arguments, those compilations.
Very well, Your
On
Lordship.
the next day, submit your written notes along with decisions you want to rely upon.
Very well, Your Lordship.
What is the citation?
It's 2019 3 SCC 572. 572.
19?
2019 3 SCC 572.
You also give the citation, whatever you want to rely. So I am giving you time.
And
both of you file the written notes of arguments.
My lord, I have given two judgments already. The Riya Devi is the latest judgment and the summarized judgment.
You give your written notes along with the compilation.
My lord, now have you finished your judgment?
No, whatever she will submit, I granted opportunity. Now I have heard both of you.
Yeah.
Now submit your written notes of arguments.
My lord, I may please draw your attention the matter which has already not clearly expressed here. Police report is the final report. When the police has finally reported it, it has been established before the court of law. This is the fact. How he has died. Because the police is under CRPC, on the then CRPC 174, police is the authority to find out the cause of the death and to take next proceedings. And police only finally, FRP has been submitted by the findings that the deceased 25A, deceased was fall down from down Lalgola, wanted Lalgola passenger train at about 1.15 hours. So there is no doubt this is the established law. Established law that he has fallen down.
Anyway, you.
My learned friend has already made his submission.
My lord, actually, inquest report, there's specifically all these things.
Anyway,
This is the actually, if I go to the court will say this your husband had died by this accident, and there is no foul play behind this death. So it is absolute. He has accident fell on from train, and he was having ticket, and ticket was, my lord, tribunal did not have any time to ask to police to issue a summon to the police authority. What you have collected, you come to the court. And really did not challenge the police report.
Any inquiry was conducted by railway authority?
No, actually
inquiry?
not conducted. Most probably, she can tell all this.
Any from the DRM side or?
That was the procedure, but that was
whether it was done as per the record.
No. তাহলে তো produce করতে court. If it has been that they should produce it before the court. They have not produced it because they have not.
Submit your written notes. Yes, record and order. Learned advocates for the parties are present. Are learned advocates. As both the learned advocates have made their submissions, opportunity is granted to them to file written notes of arguments and the decisions relied upon. Fix 19/2/2000.
1920. If you, actually 19, I'll be busy with some other case.
Okay. 23/2/2026.
Yeah. For
filing written notes of arguments. Let this matter appear on 23/2/2026 at 4 p.m.
3 actually.
Other matters are
actually most risky. Little risky.
I'll keep on the following day then.
24th.
No, 23/2/2026 at 4 p.m.
At 4 p.m.
23. If it is 3 p.m. Actually 4 p.m. it is risky. High court.
Very well. Take the risk. Take the risk. If necessary, I shall keep it again on the next day.
I'm deeply obliged.
Obliged.
আরেকটা আছে matter. Yes, item 8.
I am appealing for the response. On last occasion, day before yesterday, appellant argued this case. Finished the argument.
Are you ready today?
Yes, I am ready. May I start?
না সেই জাজমেন্ট
এই পেপার বুকটা দিন একটু।
Day before yesterday, my learned friend for the appellant argued the case and pointed out the paper book page 60.
Page 2, no?
Just recollect the memory and that I am arguing this afterwards. Page 60, my lord, under section 174 CRPC FIR shown. And then my lord, the page 61 solution
Thank you.
that is the
আমাদেরটা নিয়েছো নাকি?
what patient this accident took place and take out.
Page 61 A.
Yes. Day before yesterday, my learned friend argued on the behalf of the appellant. Just I am pointed out to recollect the lordships. Page 60 first has pointed out. That is the FIR lodged complaint was made, my lord, by the victim's relative. And my lord, the page 61 station master's report has shown before your lordship, and page 33 statement of Fatima Khatun, that is the deceased wife. And page 88, my lord, the judgment passed by the claim tribunal issues, my lord, 1.2, 2.29 and 13.3. And page 74 and page 81 to 83, evidence of mother of the victim. And then my lord, the page 86, cross-examination has pointed out.
Page 70?
Page, my lord, 74.
74.
74.
Yes.
My learned friend, if I am not wrong, my lord. And then, my lord, my learned friend has pointed out page 81 to 83, evidence of the mother of the victim and other witnesses. And page 86, cross-examination has pointed out before your lordship. And page 90, postmortem report 7.9 and 7.6. Before that, 7.6 and then 7.9. And two judgments cited, one unreported and one reported judgment, Union of India and Reena Devi's case, paragraph 10, my lord, pointed out. Here in this case, my lord, my defense was, my lord, in judgment starts from page 86, 7.4, my lord.
87.
86 starts from the claim tribunal. 7.4, my lord, railway claims tribunal.
Yes.
7. Have you also got it, my lord?
Yes, yes, yes.
Tribunal examined all documents and witnesses of these cases, concluded the final investigation report, and inquest was prepared on hearsay evidence, not direct evidence or no eyewitness, my lord, was prepared on hearsay evidence.
That is
as
page?
There was no eyewitness.
So page, which page?
Page, my lord, para 7.4, judgment.
Para 7.
Para 7.4, my lord, kindness, yes, my lord.
Yes, para 7.4.
Yes.
Yes, yes.
Page 89, my lord.
Page 90.
Page 89. 7.4, yes, sorry. 7. Page 90, my lord.
Yes.
Sorry, page 90. And 7.5 on the same page, my lord, a railway witness has given, my lord, that is the porter in the it is clear that he was not the eyewitness of this incident. In his cross-examination, the said railway witness 1 has specifically stated on duty roster, a porter, Saidul Rahman, informed him about the incident and the inquest report where he had put his signature. Half of that report was blank and the half of that report was filled up. Moreover, in the investigation report, it has mentioned that perhaps the victim might have fallen down from any up or down train, which indicates that the investigation report was prepared based on assumption and presumption. Further, in the RPF diary annexed with DRM's report, my lord, I am pointed out the DRM's report, I placed, my lord, afterwards, my lord. It is mentioned that body of the victim was found between up and down main line and his right leg was cut from below knee and was lying inside the track at about 50 meters away from the dead body. 50 meters from the railway track, my lord. Long, not railway beside the railway track or near about the railway, my lord. Next, my lord, the 7.6, my lord, the paragraphs 7.6, my lord, the page 91. This is the applicant has not produced any eyewitnesses corroborating the fact as alleged by her. That is the, my lord, the 7.6 complete analysis of the PM report.
Only one witness was examined by the claimant.
Fatema Khatun, my lord. And no ticket was recovered. Only, my lord, the Aadhaar card and the PAN card was recovered from victim's dead body recovered, my lord. And 7.12, my lord, kindly see, learned tribunal, the 7.12, my lord, I am pointing out, page 93. The learned tribunal claimant failed to prove that the deceased boarded any train, only his body was found beside the track. No ticket was recovered from his custody or no ticket, my lord. And then, my lord, the 7.13. On the same page, 93. From the RPF diary, it is found that money bag, voter ID card and ATM card were recovered, but no journey ticket was recovered from the deceased. It is highly improbable that everything was recovered and only the journey ticket which the deceased was performing his journey as alleged was lost.
So the journey ticket could not be submitted by neither the police authority nor by the railway.
No ticket has recovered from the, my lord, the victim.
Okay,
no ticket was the victim. Only victim recovered voter card and Aadhaar card
from his
and money back from his custody, my lord. 50 meters from the away from the track, the dead body was recovered.
No, 50 meters away from which track? That is from
That is, my lord, the during the journey, my lord, that is, I am pointed out.
They can reproduce difference between.
Kindly see the page 44, Gaur Gopal Ghosh ASI.
44,
my lord, in the paper. ASI RPF, Railway Protection Force. On being asked, have you lost it? Got it, my lord?
44, yes.
44. ASI Tiki Ghosh state voluntarily without any fear, inducement or prejudice that perform my duty as supervision in charge of camping RPF staff as Jamir Ghata railway station. On 23rd September 2021, I received information at about 16:15 hours from JMQSM. I, along with CT Amit Kumar, immediately attended the spot and found one male dead body was lying in between up and down main line at KM number 277/8 near JMQ railway station, and his right leg cut from below knee, laying inside the track at about 50 meters away from the dead body.
That means this person was was boarded train from which, as per the claimant's case?
That
Boarded-
yes, boarded the claimant's case. The
No, as per the case of the claimant.
claimant, yes.
For example, ticket was
Ticket
not
was not-
found. So as per the case of the claimant, the person, the victim boarded train from Shialda.
Shialda.
And victim was scheduled to go to which place as per the claimant's case?
Claimant's case, my lord.
As per
Yes.
Coachbihar.
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 Padatik Express.
And the train is Padatik Express.
Padatik Express.
And which place the body was found?
What is Jamin Nagar, my lord? I have pointed out.
Jamir Kata railway.
Jamir Kata.
Jamir Kata.
Which is in
Jamir
between.
Ghata.
Jamir Kata. That
Jamir
is
Ghata railway station. That's why, my lord,
that is in North Bengal. That is
No, just after Rampurhat and before Malda.
that is yes. Near about, my lord, the
It is near Malda.
near. Not Bengal.
right leg cut.
Yes, Gaur Gopal Ghosh at that material point of time was on duty at the relevant. That's why, my lord, the ASI, RPF, Railway Protection Force, made a witness before the tribunal, my lord. Statement of Gaur Gopal Ghosh. Sometime every angle, and my lord, after some time at about 8:30 hours, ASI Dulal Mundol along with staff of GRP Malda attend the spot place of occurrence, PO. Then taking picture from every angle, and after it personal search was done. During personal search, one blank color money bag found in which one voter card and one ATM card of Union Bank was found. The full address of deceased person was detected as per voter card, but no any railway ticket or authority was found. That is the vital matter. No ticket was found. The dead body was removed by the GRP Malda after completion of all legal formalities and sent the dead body to Malda hospital. That is my defense was that, my lord. And that is the DRM report, my lord. Kindly see page 15 paper.
Yes.
Page 15 have got it. From top 5 lines, middle, as per DRM report.
Page 50.
No, 15, 15, 15.
Yes.
From top 5 lines after. As per the DRM report. Have you also got it?
Yes, yes.
No railway ticket was found from the possession of the victim, as well as no eyewitness was found who could prove that the deceased person had fallen down from the alleged train number 12377 stroke 02377 Padatik Express. Moreover, on duty guard and loco pilot of the said train stated that neither they noticed any such incident nor received information from any corner, hence the reason of the incident could not be ascertained. That is the DRM report. And it was considered by the learned tribunal. And claim has refused, that is the witness and report, my lord. And kindly see more witnesses, that is the station master, my lord. Page 42. Evidence. Biswajit Murmu. Jamirghata railway station. That incident was occurred at that material point of time.
Yes.
Have you also got it, man?
Yes,
Quote
yes,
two.
yes.
That on being asked, I Biswajit Murmu, SM of JMQ railway station, state voluntarily without any fear, inducement and prejudice that I was detained duty as SM from 00 hours to 8 hours, date on 23rd 9 2021 at Jamirghata railway station. On 23rd September 2021, I was performing duty as SM JMQ. During my duty period at about 6:13 hours, I received an information from Saidur Rahman, porter of Jamirghata railway station over phone that one unknown male person aged about 31 years laying at claim number 277/8 in dead condition in between up-down main line near JMQ railway station. Then he informed to section control Malda and RPF Jamirghata and issued a memo RPF JMQ regarding it. After some time, officer and staff of GRP Malda attend the spot, place of occurrence and remove dead body after legal formalities as per best of my knowledge and diary record. This is my statement. That is the statement made before the Honorable Tribunal, my lord. That is the station manager, station master. And my lord, the final inquiry report also placed before the tribunal. Also, my lord, we kindly see page 29. It starts from Post Commandant.
This
final
is the by
report,
the
page 29, 29.
yes, by the GRP.
GRP, my lord. Submission of final inquiry.
No,
report.
any separate inquiry conducted by Railway Authority.
Railway Authority, my lord, also
Separately has
DRM report.
DRM.
My lord, I have pointed out that is the DRM report also.
So previous one was the DRM report.
DRM report, yes. My lord, I pointed out my lord, page 15. Page 15.
Page 15 is the
Yes,
DRM report.
DRM report. As per the DRM report.
No, this is the opposition objection.
Yeah, objection, my lord. DRM report, my lord.
DRM
Yes.
report means there is a separate DRM report.
Yes, my lord. That is pointed out in the.
Now let us see this thing, GRP report.
And Marty, that is the Honorable Tribunal, my lord. Kindly see page 88. That is there 3 points. Whether the considerable for victim's family is entitled to get the compensation or not. Page 88. That is the issues has been framed by the Honorable Claim Tribunal. Whether the incident on account of which the deceased is alleged to have died can be termed as an untoward incident within the provision of section 123C, C2 of the Railways Act. Whether the victim was a bona fide railway passenger on the day of the incident in terms of section 229 of the Railways Act. Whether the applicants and others are the dependents of the deceased in terms of section 123B of the Railways Act and are entitled to get any compensation from the respondent railway. Relief, if any. That is that, that is the section.
No, what is the bona fide passenger as per the definition?
Yes, bona fide
he must have a
passenger,
ticket.
yes, ticketless person. That person is not the bona fide passenger as per the section
so let us
29 of the Railways Act.
Let us read out that.
Yes, I am reading.
220.
I am reading 220, section 2, subsection 29. Passenger, I am reading, my lord. Section 229, passengers means a person traveling with a valid pass or ticket. My lord, I am handed over. I tender my apology to Mark for the pain.
Yes, valid pass or ticket.
Yes. There is no valid ticket, only ATM card and Aadhaar card
this
and
is
money.
Passenger and bona fide passenger, that is
that
is not there.
That is not there.
Unless you travel with a valid pass on ticket, you are not treated to be a passenger. You have to be a trespasser.
Trespassers, definitely. And my learned friend pointed out that is the Rina Devi's case, my lord. That is, I am reading, that is the relevant portion, para 10, on last occasion as cited, my lord. That is no, paragraph 29. I am reading, then I am handed over, my lord. Union of India versus Rina Devi. We thus hold that mere presence of a body on the railway premises will not be conclusive to hold that injured or deceased was a bona fide passenger for which claim for compensation could be maintained. However, mere absence of ticket with such injured or deceased will not negative the claim that he was a bona fide passenger. Initial burden will be on the claimant, which can be discharged by filing an affidavit of the relevant facts, and burden will then shift on the railways. They have not proved. Then, my lord, the issue can be decided on the facts shown or the attending circumstances. That is the case, varies fact to fact, my lord. These will have to be dealt with from case to case on the basis of facts found. The legal proposition in this regard will stand explained accordingly. I have handed over. That is the Joseph. I am tender my apology to underline this one. On last occasion, my lordship, my learned friend has shown the paragraph 29 of that judgment. So this is not the case. This judgment is not applicable in this matter. My humble submission before you.
Yes.
DRM reporter. DRM reporter.
So what are the ground of rejection? First is
That is the they have not put kindly see.
The non-recovery of ticket and the other?
Kindly, that is the page 94, the last tribunal's order, my lord. I am reading, my lord. 94 page. In this regard, the observation of the Honorable Allahabad High Court suggests it is mentioned that the above judgment that the case of ticket is not found from the body of the deceased or from its vicinity, the presumption could be sent as such person was not a bona fide passenger. Of course, evidence can be laid to the proof otherwise. In another case, that is this coupled with the facts 7.18. No journey ticket has been filed on record. Accordingly, the tribunal cannot conclude that the victim was a bona fide railway passenger at the time of occurrence of the alleged incident, which resulted in this death. In view of our discussions, we are of the view that the claimants have failed to prove that the deceased was a bona fide passenger or sufferer of an untoward incident. Accordingly, both the issues are decided against the applicant. Since the issue number 1 and 2 are decided against the applicants and in favor of the railway, as such, it will be a redundant exercise to adjudicate qua the remaining the issues. In view of the decision held above, the claim application being devoid of merits is hereby dismissed with no order as to cost. Accordingly, claim application is dismissed.
Yes.
This is my submission.
So, anyway, submit your written notes on the next day. Yes, record an order.
My lord, one thing, two things I would very short. I shall be very short on my. My lord, one thing, my lord, what my learned friend was submitting that I am just pointing out initial burden will be on the claimant, which can be discharged by filing an affidavit of the relevant facts, and burden will then shift on the railways, and the issues can be decided and facts on and on or the attending circumstances. My lord, here the affidavit which my learned friend has for his interest has not mentioned, my lord. Here the affidavit has been filed. So they cannot escape their liability and file bank on a incorrect judgment, based on a total incorrect proposition and defend that judgment. My lord, it is my humble submission. I am not.
Apart from this, did you cite any other decision?
My lord, and the Dolirani Shah I have filed, my lord.
Anyway, so give it in your written notes.
And my lord,
learned advocate.
My lord, another decision.
You give it in your written notes, compilation, give your written arguments and the compilation. Learned advocates for the parties are present. Learned advocates, as learned advocates have concluded their submissions, They are permitted to file written notes of arguments. Let this matter appear on 19th. 19.
My lord, in this matter, sir, I am recent one judgment. Justice Ononabandamata recent. There is
Yes, my lord.
for bona fide regarding bona fide.
Give it in your
19. There was no ticket.
Anyway, give it in your written notes. 19/2/2026 at 4 p.m.
Yes.
My lord, kindly make it, let it be 20th or someday, my lord, let it be on
It's not possible.
then my
Okay.
lord, subsequent any date, my lord, 4 p.m.
Okay, 24/2/2026 at 4 p.m.
24.
My lord, 3 p.m. any date, my lord. Anywhere it's 3 p.m. my lord.
No, actually, I have to fix other matters at 3 p.m.
That's right. 4 p.m. Joseph, 4 p.m. That's only to submit the written notes of argument.
It will not take.
Yeah, yes, it will not take that.
And if there is 3:30, I
Yes.
should consider on the next.
Definitely. At 4 p.m. my lord, 24th.
Yes.
24th or 4 p.m.
24th. আরে written notes of তাতে তুমি জাজমেন্ট গুলো দিয়ে দেবে আমাদের জাজমেন্ট গুলো সেগুলো দিয়ে দেবো রিলেভেন্ট কোশ্চেন গুলো আমরা এক্সপ্লেন করব
Come tomorrow, okay? I shall see.
The last week
I shall see. It may not be, if not possible tomorrow, for the next week.
That's why there is untold incident for pen down of the court.
I shall take it up there on Monday.
Yes. 41 item number.
Yes.
Number 41, my lord, that's the matter.
Yes, you mention. If you want, you can mention.
Item number 1, which has been paid today at 4 p.m. for order.
Okay, come on the next day. Today orders have to come.
But my commission is below, the entire appeal should be heard.
Whatever it is, you come ready on the next day.
My lord, item number 19.
Yes.
It is already parted.
Whatever it is, I shall see.
I am for the opinion. You also make it part, but there is no part one.
19.
9. Item 9.
No. 9 is
9. Item 9, my lord.
Item 9.
Okay. 9. You have commenced your submissions. Oh, you have commenced your submissions.
My lord, I am submitting.
Okay, I shall take it up.
My lord.
The next. Anyway, another date will be fixed. On another day, it will appear as to be mentioned. Another date, suitable date will be fixed.